Fourth schedule of the Constitution, where the Deputy President is accused of undermining devolution. The mover of the motion in his motion states that on the 20th of September 2024, His Excellency Rigathi Gachagua, recklessly and mindful of the high calling and dignified status of the office of the Deputy President, unlawfully interfered with the running of the Nairobi County government by holding a public rally in which he incited citizens against lawful directives by the Nairobi City County government on the planning and relocation of markets. This is just some of the grounds listed or some of the annexes under charge number 3, where the Deputy President is set to defend himself on these charges, among others.
Senior Counsel Paul Mwita, your time started running.
Mheshimiwa Speaker, may I...
Let me just conclude, Senior. Your time started running at the time I requested you to usher in your witness. You indicated that you're getting hold of your witness. We'll give you all the time you need to get hold of your witness, but to let you know that the clock is running, and it's running on your client. You can take all the time, but his time is running out. After 2 hours, he's not appeared, the chair will make a ruling pursuant to the rules of procedure.
Mheshimiwa Speaker, may I start first and foremost by expressing apologies and regrets that the Deputy President is not here, and by not being here, the inconvenience and delay caused to Mheshimiwa Speaker and to honorable senators. The position, Mheshimiwa Speaker, is that during that period that I went to try to find out why he wasn't here, because as Mheshimiwa Speaker knows, the Deputy President has been coming here absolutely punctually every day. It is that the Deputy President very sick, and as I address Mr. Speaker in this honorable House, senators, he is in hospital, Mheshimiwa Speaker. That is a sad reality.
Order, honorable senators. Order, honorable senators. Senator Kajwang. Now, Counsel for the National Assembly, you have had Senior Counsel Paul Mwita for and on behalf of the Deputy President. Considering that this is a time-bound process, What is your reaction?
Mr. Speaker, sir, this is a house governed by the rule of law. We truly empathize with the difficulty that His Excellency, the Deputy President, has found himself in. But, Mr. Speaker, sir, pursuant to Rule 11 of the rules governing this process, if I may, with your permission,
maybe Counsel for the National Assembly.
Yes, Mr. Speaker, sir.
Just take a seat before you make your rejoinder. Senior Counsel Paul Mwite, having said whatever you've said, what is your proposed way forward so that a reaction can be put from the National Assembly? Are you telling us we wait until your client gets here? What is your proposed way forward?
Mheshimiwa Speaker, I have just received this information. My proposal is that you give me at least the rest of the day. I would like to go and have an assessment of his situation and maybe even come back here by 5 p.m. Right now, I would like to make an informed sort of situation after I see the Deputy President and I see the doctor, Mheshimiwa Speaker, at least an hour or two. Yes, thank you.
Very well. Counsel for the National Assembly.
Mr. Speaker, sir, having very keenly listened to my learned senior colleague, Paul Mwite, Senior Counsel, it puts us in a bit of a difficulty because whereas we may want to empathize with the situation, there appears to be no indication from their end as to a specific proposal. Mr. Speaker, sir, this being a house governed by rules and this process being a time-bound process, I will draw your attention to Rule 11 of the rules of this House. If I may read, Mr. Speaker, sir, that where the National Assembly or the President chooses not to appear before the Senate, that fact shall be put on record and the Senate shall proceed with its investigation without further reference to the National Assembly or the President. But the Senate may, for exceptional reasons to be recorded, permit a later appearance before the Senate by the National Assembly or the President. Mr. Speaker, sir, I think this rule would give us guidance we may proceed. If it becomes necessary, then any additional material may then be availed. This is a time-bound constitutional process, Mr. Speaker, sir. I'm most obliged.
Let me pick the wisdom of my wonderful senators before I make my decision on the way forward. Now, I understand that all of you are wise men and women.
Speaker, can I just say a word?
Yes.
I've heard what Senior Counsel Paul Mwite has said. And, Mr. Speaker, you have made it quite clear that these proceedings are time-bound. It's not so much about the situation in which His Excellency the Vice President finds himself. It's about the Senate complying with the provisions of the Constitution. That within that time frame, you must make a decision. Reading the standing orders that my learned friend, Mr. Rick Gumbo, has referred to, it would be useful to this House if Senior Counsel Paul Mwite could probably give us a way forward in terms of the the time limitation that the Senate has. I'm saying this because we don't want somebody to say that the Deputy President was not given an opportunity to be heard. I think the Senate will want him to be heard. But knowing the time limitation, what suggestions does the Senior Counsel have to ensure that we keep within the time parameters? At the same time, the Deputy President is given his space to defend himself.
So we have two sides. We have the minority side and the majority side. I will only allow the two leaders to speak. If you need to consult in the next 1 minute. Now, honorable senators, our standing orders have not been suspended yet. It is only Senator Mazayo and the majority leader who. The rest, take your seat. The rest, please take your seat. Order, honorable senators. Honorable Senators, we are facing a very unprecedented situation. At the rise of this House at 1:15, I indicated that upon resumption, we were going to hear the Deputy President. Upon resumption, Senior Counsel Paul Mwite, for and on behalf of the Deputy President, when I asked him to usher in the Deputy President for purposes of presenting him to give his evidence in chief, the Senior Counsel indicated that even he was unaware of the whereabouts of his client, and he asked for a few minutes to go fetch him wherever he was. After a few minutes, Senior Counsel Paul Mwite came back to the chamber and indicated that he had gotten information which he was yet to verify, that his client had fallen sick, and indicated that he needed time to go look for him in whichever hospital he is, and that he should be given up to 5 p.m. today. The Counsel for the National Assembly, in response, indicated that this is a time-bound process. He referred to the Senate to rule Rule 11 of our Rules of Procedure, that where the Deputy President fails to appear, the Senate can actually proceed, or for exceptional reasons to be recorded, permit a later appearance before the Senate of the Deputy President. Having considered the two sides, my directions are as follows: that we will suspend this sitting and resume at exactly 5. So the Deputy President, we expect the Deputy President then to take the witness stand at 5. This is a time-bound process, unfortunately. It is so ordered.
Will make sure
Has not deserted you.
It is always a risk in this type of business, Honorable Speaker, but I'm sure he's around.
So, Council, before you proceed, you first introduce yourself.
Yes, walk us through that letter of offer.
So there is a letter of offer, meaning there was an application for a loan. And this is to the directors of Crystal Kenya Limited. Crystal Kenya Limited is the company that is acquiring Aberdare Safari Lodges. And the loan is in respect of an amount of 600 million. And in the clause for lien and set-off, I have seen that a lien and set-off or fixed deposits, this is on page 99, in respect of INO Crystal Kenya Limited for an aggregate amount of 300 million to be obtained. Interest accrued shall be credited to your deposit settlement account.
Let's stick to that one for now.
Your deposit settlement account.
Let's stick to that one for now. From elementary banking knowledge, what do we conclude from this issue of the 300 million?
My understanding is that the account held at the bank had 300 million shillings in cash, and that that amount was going to be part of the security for the loan.
So it means the deputy president or his sons had already cash in that account of 300 million shillings.
Yes, which is also an asset that we are counting in calculating the 5.2 billion.
Now let's count that 300 million, 535 million, and the 143 million that had been to be paid to pave way for this transaction.
Indeed, yes.
In estimate, that would be like how much money?
535 plus 300
is 835.
835 plus 143, roughly $1 billion shillings.
Roughly $1 billion shillings.
In respect of one transaction.
Just one property. Now, if the deputy president were to save all his net salary for 10 years, would he be able to have savings of $1 billion shillings to acquire this hotel?
Not at all.
But because
from the legitimate source of income, which is his salary as deputy president, as gazetted by the SRC, roughly around 1.2 billion after taxation, an aggregate of $1 million shillings, it would not be possible to acquire $1 billion shillings within a period of 2 years.
Now, these three figures, whether it is the 143 million, or the 300 million, or the 535 million, as the deputy president in his response offered any legitimate explanation of how he or his very young sons came upon this incredible fortune of money?
Nowhere in the response, other than the letter of offer that is in itself not evidence of acquiring a loan.
At page 39, who are shown as the parties to this transaction for Aberdare's Hotel?
Page 39 of
volume 2A.
At page 39 of volume 2A, the parties to this transaction for Crystal Kenya Limited, Kevin Gachagua Rigathi and Keith Ikino Rigathi. For Aberdare Safari Hotels, there is Robert Gadenji,
Yes.
and Kenneth Waiboshi.
Are those two gentlemen you mentioned first related to the deputy president?
Indeed, they are his children.
As a matter of fact, Honorable Mutusend will do it in the closing statement. Does our Public Officer Ethics Act or the Leadership and Integrity Act, faced with facts like this, permit the deputy president to hide behind his sons?
Not at all.
Is he allowed to hide behind any of his relatives?
Not at all.
What about his spouse?
Not at all.
So even if the Senate were to accept, for argument's sake, that this company is run by the sons and whatnot, would that, based on our Public Officer Ethics Act or the other act, which is the leadership, answer to this unexplained wealth?
Section 35 of the leadership, state officer contravenes the code if the officer A causes anything to be done through another person that would constitute a contravention of the code if done by the state officer, or allows or directs a person under their supervision or control to do anything that is in contravention of the code.
Mr. Speaker, acting through others is what previously I have called it wasn't me. But let's jump to page 79 of volume 2A.
Yes, we are here.
Again, this is documentation for that same property the Deputy President admits he acquired, right?
Yes, through Aberdare. Just for contextualization, Aberdare owned 2 hotels.
Yes.
There is Treetops Hotel.
Yes.
And there is
which one?
Outspan.
Yes.
Outspan is the one that we have demonstrated how it was purchased. Treetops is a property developed by the Kenya Wildlife Service, but it was under the same management of Aberdare, so they were acquired together.
So let's pause at it is owned by the Kenya Wildlife Service.
Yes.
Is the Kenya Wildlife Service a public or a private entity?
A public entity funded by the taxpayers.
Under our Chapter 6 laws, that is the Public Officer Ethics Act, the Leadership and the Integrity Act, if you want, you can even draw the Public Procurement and Disposal Act, whichever law. Is it consistent with all those laws for the Deputy President of the Republic to acquire without competitive bidding an interest in a resource owned by the Kenya Wildlife Service?
It is not. And in fact, the Deputy President is on record in these proceedings as having said that he has advised his family not to transact with government. But we are going to demonstrate that he actually transacted with KWS.
And KWS is a public entity?
And KWS is a public entity.
If this hotel were to be leased or sold, or whatever the language, would there be a requirement for open, competitive, and transparent bidding?
Section 45, which we said we have reasonable grounds to believe that the Deputy President has breached of the Anti-Corruption and Economic Crimes Act. And I'm reading volume 7 at page 23, states as follows: protection of public property and revenue. A person is guilty of an offense if the person fraudulently or otherwise unlawfully A, acquires public property or public service or benefit, B, mortgages, charges, or disposes of any public property, C, damages public property including causing a computer or another electronic machinery to perform any function that directly or indirectly results in a loss or adversely affects any public revenue or service, or fails to pay any taxes or any fees, levies, charges payable to any public body, or effects or obtains an exemption, remission, reduction, or abatement from payment of any such taxes, levies, and fees. Section 46, about abuse of office. A person who uses his office to improperly confer a benefit on himself or anyone else is guilty of an offense.
Now, let's go to page 81 of volume 2A, sir. It's still about Treetops Hotel.
Page
81 of
yes.
volume 2A.
I'm there.
Can you read for us the last sentence of the second paragraph?
This is a letter. This is a letter from the Kenya Wildlife Service.
Yes.
To Mr. Amos Kisilo of Kisilo and Wandati Company Advocates.
It's a letter dated when?
The letter is dated
at the top left. What is the date?
5th of June, 2023.
Was His Excellency, the Honorable Rigathi Gachagua, the Deputy President of Kenya on that date?
Yes.
It is addressed to who?
It is addressed to Kisilo Wandati and Company Advocates.
In the Deputy President's own response, is that law firm indicated as one of the law firms he uses?
Yes, indeed.
Good. Now read for us the second paragraph of that letter, beginning with the word however.
However, the tenant is in rent arrears of Kenya shillings 35,481,548, and lodge has not been operational since 2019, which has resulted to deterioration of the same in breach of the lease agreement.
So we are being told this hotel a number of things. One, it has not been in operation for 4 years, correct?
Indeed.
And as a result, it has accumulated
rent arrears, correct or incorrect?
And deteriorated, which in effect means it requires renovation money.
Now let's go to page 80 where the Deputy President develops interest in the hotel.
I'm here.
Can you read the opening line of that, the first paragraph of that letter?
Mr. Speaker, Honorable Senators, this is a letter from Kisilo Wandati and Company Advocates to the Director General of the Kenya Wildlife Service. The opening sentence reads as follows. We act for a party, into brackets our client, who is interested in taking on an assignment of lease of the Treetops Hotel Lodge as defined in the lease agreement dated 31st December 1998 between yourselves and Aberdare Safari Lodges Limited, the lessee.
Please confirm this is a letter by the Deputy President's lawyers.
This indeed is a letter by the Deputy President lawyers, but funny enough, against any all professional knowledge in terms of how you write letters, they do not disclose their client. They just say party.
Who is our, does that letter disclose the identity of the client anyway?
No, it doesn't. And it is a requirement that you must disclose the client even as you move ahead.
Is that how lawyers usually write letters in honest, genuine transactions?
Not at all.
Good. Now let's go.
And I am one of them, so I know.
Let's go to page 83 of volume 2A. What is written there?
Page 83 is a letter to Dr. Kanga, Director General Acting, Kenya Wildlife Service from Aberdare Safari Hotels.
So,
it is about Treetops Lodge debt and lease.
Please hold 83 together with 81. In 81, we are told the hotel has not been in operation for 4 years, and that's why it's in rent arrears, right?
Yes, rent arrears of upwards of 35 million.
And that is on which date?
This is on 5th of June 2023.
And the letter at page 83 is on what date?
It's 7th of July 2023, a month later.
How many days in between, roughly?
Roughly a month, 30 days or so.
Roughly a month. And what does this letter say?
The letter says, I refer to Treetops rent arrears debt of Kenya shillings 35,481,548.14, and I am pleased to inform you that the Aberdare Safari Hotels Limited has today paid via RTGS bank transfer amount of 34,869,797 to KWS main collection standard chartered bank account, and the amount of 611 to KRIF for 2% withholding tax.
So, Honorable Mutuse, what do you have to tell the Senate of the fact a company that was in arrears for 4 years, 35 million, it is in distress, it's not in operation, the Deputy President shows interest, and suddenly it is able to pay these arrears of that 5 million?
The Deputy President must be magical. Associating with the Deputy President must be very magical, because you have not operated for over 4 years. You are in debt. You have not been able to service that debt for 4 years, but you have just interacted with him for a month, and you pay your debt overnight.
Now, when you see that, sir, is it consistent with the narrative that your allegations are false, ridiculous, and embarrassing?
Not at all. Indeed, our allegations are backed up by cogent evidence, as we have demonstrated.
What is the document at page 85 of volume 2A?
At page 85, this is a letter by Kenya Wildlife Service to our one Ken Waiboshi, who is the managing director of Aberdare Safari Lodges, and it is acknowledgement of funds.
How much money?
We acknowledge, the letter reads as follows in paragraph 2, we acknowledge receipt of Kenya shillings 34,481.
As the Deputy President in his response explained, the mysterious availability of these 35 million shillings when he comes to the picture?
I have not seen anywhere where it explains where this money came from.
Page 87, what is that document?
At page 87.
Of volume 2A, Mr. Speaker.
This is a novation and assignment of lease agreement and addendum to lease dated 31st December 1998 and 27th July 2023, respectively, between Kenya Wildlife Service, Aberdare Safari Lodges Limited, and Crystal Kenya Limited, the company of interest.
Does this confirm, just like the deputy admitted, that he actually acquired Treetops Hotel?
Indeed, it confirms, and it is not. It has not been contested.
Is your allegation, therefore, Mr. Mutuse, about Treetops, false, ridiculous, and embarrassing?
Come again?
The evidence you just taken the Senate through about Treetops Hotel, is it consistent with the narrative of a move of motion who makes ridiculous, false, and embarrassing claims?
Not at all. It demonstrates that our allegations are not malicious. They are backed.
Let's go to his response in volume 6. It should be page 8, if I'm not mistaken, Mr. Speaker. Eight of volume 6.
Yes, there we are. Volume 6. On page.
Okay. Is page 9?
Yes.
At the top of page 9, what does the Deputy President in his response to the National Assembly tell it?
He says, in respect to Crystal Kenya Limited, this company was incorporated in 2009, way before I became Deputy President.
Let's pause there. Is that a valid response to your motion, the date when the company was incorporated?
I am interested in what the company did when Mr. Rigathi Gachagua is Deputy President, and not when the company was incorporated.
Okay, read for us the next line.
I transferred the company to my sons when I became Deputy President.
Is that a valid answer given the things we've just seen about Treetops and Outspan?
It confirms that the sons indeed are acting on his behalf.
Read the next line, please.
It acquired Outspan Hotel and Treetops Hotel following financing by a local bank. I also gave the company a personal loan from funds which were returned to me by the Asset Recovery Agency. I wish to clarify that Treetops Hotel was not bought. It is leased from KWS. The lease was assigned to Crystal Kenya Limited by a private company, Aberdare Safari Hotels Limited. I have annexed the facility letter dated 24th October as well as the company resolution to borrow Kenya shillings 600 million and marked as Annex RG 14 and Annex RG 15 respectively.
Let's go to page 44.
This relates to the property called Rogoro Kiamariga 1223.
This is in volume 2?
2A. Volume 2A, Mr. Speaker, page 44. Please confirm from the Deputy President's response whether he has admitted acquiring this property.
Yes, he admits acquiring the property, but goes ahead to make some justifications.
Page 44, Mr. Speaker, volume 2A. The justification he makes is to what effect?
Is that the acreage is different,
Yes.
and also that he bought it for 3.5 million and not
Yes.
5 million as alleged.
Now let's go to that page 44. What is that document?
This is a document transferred by person or representative to person on intestacy. Basically,
And who is given that who is given that transfer? Who is making it?
a certain Naftali Guandraru Gadhogo,
Can you read the opening line of that document?
Public Trustee of the Republic of Kenya, or PO Box 49672 Nairobi, as personal representatives of Naftali Garandau Gadhogo, deceased, hereby transferred to Hannah Gadhongo Mugo. Absolutely.
Who is the public trustee a public officer?
The public trustee is a public office, is under public.
Under what circumstances, to the best of your knowledge, does the public trustee obtain letters of administration of an estate, in this case the estate of the deceased Naftali Gwandaru Gadhogo?
In terms of the law of succession, the public trustee only steps in where there are no beneficiaries of a deceased person's estate.
The person to whom the trustee is transferring, is there a picture given there?
Yes, it is given, and I will invite.
What observation do you want them to make about it?
Well, this is a photograph of, I do not want to say disheveled, old lady who signs by appending her thumb, signifying probably she was not even aware of the transaction.
Has she signed or affixed a thumbprint?
A thumbprint.
On the face of it, does that look like a privileged or vulnerable and marginalized Kenyan?
The very vulnerable.
Mr. Speaker, sir, kindly allow me again to bring to the attention of the Assembly that the advocate is leading the witness. He has put a question. Does that, in your own imagination, look like a vulnerable person?
Objection sustained. Counsel for National Assembly, stop leading the witness.
I'm much guided, Mr. Speaker, so we'll proceed. We're on page?
We are on page 44.
44. Did the Deputy President, in his response, disclose that this property initially belonged to a deceased person?
No.
Did he, in his response, disclose that this property was initially vested on the public trustee?
No, he didn't.
Let's go to his response at paragraph 1.4.2, which is on volume 6, Mr. Speaker. Page 4 of volume 6. Can you read paragraph 1.4.2 of the Deputy President's response?
I purchased the land in the year 2023 for Kenya shillings 3.5 million for my farm proceeds. Some of you are aware that I have dairy farm with close to 200 cows.
Now, let's see who is saying things that are embarrassing, false, and ridiculous. What is the price he has said he acquired it for in that page?
3.5 million Kenya shillings.
Let's go to the agreement he has attached to show how he purchased this property. It is at page 63 of the same volume.
I am here.
Clause number 3, what is given as the purchase price?
The purchase price is Kenya shillings 5 million only, to be paid as follows.
Is that consistent?
This is,
volume,
this is
6,
volume 6.
We are holding, Mr. Speaker, volume 6, pages 4 and 63. No, it is page 4 of 534 and page 96 of 534. The problem, Mr. Speaker, is there are two sets of pagination. So the one we refer to is the one that says of 534. So we are talking of page 4 of 534. You hold that together with page 96 of 534. My apologies, Mr. Speaker.
In other words, go to page 4 and page 96, or
Or 534? Or volume 6?
Yes.
We'll shortly take you to the paragraphs.
Mr. Speaker, you know I'm under a lot of pressure because of the time. That's why sometimes. So, are we all there, honorable senators? Good. Can you read again for the Senate on page 4 of 534 what the Deputy President says was the purchase price for this property?
This is land parcel number Ruguru, Kiamariga, 1223 in Madera East constituency. That is on page 3. And on page 4, the Deputy President says, I purchased the land in 2023 for Kenya shillings 3.5 million for my farm proceeds.
Let's pause it there. He bought it for 3.5 million. Let's go to the document he has annexed to prove that he acquired this property for 3.5 million. It is at page 96 of 534.
Indeed, this is agreement for sale of the whole of LR number title Ruguru Kiamariga 1223, measuring approximately 2.5 acres. And under clause 3, the purchase price is Kenya shillings 5 million to be paid as follows.
Given this inconsistency, sir, is it fair for the Deputy President, when he is lying on his own document, to accuse you of presenting material that is false, ridiculous, and embarrassing?
It is not fair, and also, especially when one of our allegations against the Deputy President is that he consistently misleads the public.
He says that he bought it in the year, back to page 4 of 534, in the year 2023. Was that during his tenure as Deputy President?
Indeed.
He says he has a dairy farm there with 200 cows.
Indeed, he says so.
In his presser on the 7th of October 2024, what did he tell the country was the source of these 200 cows?
If I remember correctly, in the televised address by the Deputy President on that fateful night, he did say that the Kalenjin people of the Rift Valley have gifted him the cows that he keeps in his farm.
Can you now read for us Article 76(1) of the Constitution, what it says about gifts given to public officers?
Article 76, Financial Property of State Officers. 76(1). A gift or donation to a state officer or a public or official on a public or official occasion is a gift or donation to the Republic and shall be delivered to the state unless exempted under an act of Parliament.
Has the Deputy President presented any evidence that he surrendered these gifts to the state?
He says that he has kept them in his farm.
Wouldn't that be an admission by his own public statement of violating Chapter 6?
Indeed, it is an admission and should be treated as such.
Let's go to the land in Meru. Have you placed any evidence to prove this allegation?
I have placed evidence to prove that the Deputy President indeed acquired land in Meru, and to the best of my recollection, he has also admitted in his response to having bought land in Meru.
I now want you to hold volume 8 against the President's response. Yes. Let's go to, first of all, volume 6, which is the Deputy President's response. What does he say about the Olive Garden Hotel? In summary, it's clause 1.1.1 all the way.
For clarity, Council, so
Yes.
we leave the issue of Meru, we'll come to
We'll come to it later, don't worry. Let's deal with Olive Garden Hotel for now. Volume 6 of which is the Deputy President's response.
We made an allegation that Deputy President has bought Olive Garden Hotel through proxies.
Volume 6, page?
Volume 6, page 2 of 534. Page 2 of 534.
Mr. Speaker, honorable senators, in my motion, I made allegations that the Deputy President has bought the Olive Garden Hotel, initially owned by his late brother. And in response, the Deputy President said as follows: the allegation that I own Olive Garden Hotel is false. The truth is that Olive Garden Hotel used to belong to my deceased brother, the late Honorable James Nderito Gachagua, and therefore has never been my property. This is information that most of you may be aware of, as it is in the public domain. Upon his demise, my late brother left a will in which, in his recognition that I am an honest man.
We can leave it there, and honest man is written in bold, right?
He appointed me as one of the executors of his estate.
Now, is the DP's response about Olive Garden, which runs from page 2 to 3, consistent with the affidavit in the National Assembly's Volume 8 by Peterson, Jomo Mushira?
Maybe so that we can point members. On Volume 8, we have the affidavit of Mr. Peterson Jomo Mushira. And
tell us in summary, because we are so pressed for time.
Peterson Jomo Mushira says, approval from office by impeachment of Mr. Rigathi Gachagua, the Deputy President. I have personal knowledge of the facts relating to the sale of Olive Garden Hotel, which initially for Gachagua. Given the matters set out in the preceding paragraph, I am competent to swear this affidavit. I decided to swear this affidavit after my attention was drawn to contradictions between the contents of Part 1.1 on pages 1-2 of the response that His Excellency Rigathi Gachagua filed at the National Assembly on 8th October in opposition to the special motion for his removal. B, remarks made by Honorable Okomas Mwengi Mutuse when prosecuting the motion at the National Assembly,
and remarks made by Honorable Kimani Ichung'wah at the National Assembly. Remarks made by members of the Assembly.
Let's go to the next paragraph in the interest of time.
I wish to clarify and state as follows. I am a shareholder and director of TM Civil Engineering Limited, the company referred to in the Agreement 4 of the Deputy President's response to the motion. On around 31st of March, the President approached and convinced me to purchase the Olive Garden Hotel, which was at the time part of the estate of the late Nderito Gachagua.
Let's go to D.
Indeed, he averts that
now
in summary...
let's go to C.
No, C. The Deputy President persuaded me to enter into an informal secret arrangement, regarding the transaction embodied in the agreement annexed on page 10 to 34 of his response to the motion. In summary, the terms of the secret agreement were that, 1, the Deputy President would buy the hotel from me by refunding the purchase price of 412 million set out in the agreement annexed on page 10 to 34 of his response. 2, the Deputy President would instruct and pay a contractor to renovate the hotel after the completion of the transaction embodied in the agreement. 3, to protect the Deputy President's undisclosed interest in the hotel, I would appoint Ms. Juliani Jahenda as the signatory or agent for the hotel's account at the Cooperative Bank of Kenya. And 4, to further protect the Deputy President's undisclosed interest, Mrs. Juliani Jahenda will run the hotel.
That Ms. Julian Jaheda, is it the same person mentioned in volume 8A on page 1 of 19? Volume 8A.
Yes, this is a letter from the Public Service Commission.
So we have two sources, one being Jomo Mushira. It is.
We are on volume 8A, page 1 of 19.
And there, the third name in that
paper. If you look at the names, you have the first one, the second one, and the third one is Maka Juliani Jahenda.
Is that the same?
Who is our Deputy Director in charge of coordination in the presidency at the Office of the Deputy President, working on a local contract.
Who is the author of this document?
The Service Commission of Kenya.
Is it consistent with what Johnson Moshera said in his affidavit about Julian Jahenda?
It shows that Julian Jahenda is a staff and a close associate of the Deputy President, and she's the same person who was seconded to manage his interest at the Olive Garden Hotel.
The acquisition of this hotel through a secret arrangement from the estate of his brother, is it consistent with a honest man as written in bold font in his response?
It is with our allegation that His Excellency the Deputy
was to be executed by the Deputy President, Mr. Honorable Rigathi Gachagua, Advocate Njoroge Rogeru, and Mr. Maina. So the children of the Deputy President were not executors of the estate, and therefore cannot be said to be in the directorship of this company by virtue of the will of the late Rigathi Gachagua, because they were not named as executors of his estate.
So is this document on its face consistent with his defense that this hotel belongs to his late brother?
It flies on the face.
But let's see whether he actually acquired it. Let's go to volume 4, page 107 of 484.
I am at volume 4, page 107.
What is that document, sir?
This is a joint will executors report on the status of the estate as at 27th February 2024. This is the estate of the late Nderito Gachagua.
And what does it tell us about Kuruwitu Home Resort in Roman 3 on that page?
The broad headline is sale of estate's assets, and it lists number 1, Queensgate, Olive Garden Hotel, and then Kuruwitu Home Resort.
Yes.
And it says as follows. The resort was sold to Kuruwitu Properties Limited for Kenya shillings 250.
What page is that volume? That's
This
volume
is,
4.
Volume 4, Mr. Speaker, page 107 of 484. Volume 4, Mr. Speaker, page...
We can continue?
Yes, proceed.
Kuruwitu Home Resort. The resort was sold to Kuruwitu Properties Limited for Kenya shillings 250 million only.
Let's stop there.
Yes.
Is Kuruwitu Properties Limited, to which this hotel or resort was sold, a company linked to the Deputy President?
Indeed, and we have annexed in our volume 2A.
Yes.
If Honorable Speaker and Senators would go to our volume 2A of our exhibits at page 8. We have volume 2A, page 8. We have annexed the form CR12 in respect of Kuruwitu.
And who are shown as the directors there?
The directors are Vipingo Beach Resort Limited.
But let's also interrogate.
Vipingo Beach Resort Limited, which we have demonstrated that is owned by Honorable Rigathi Gachagua's children.
Back to volume 4, page 111 of 484. Can you read at the top the sentence that begins with, for instance?
This is, we are at page 111, and this
is 484, Mr. Speaker, volume 4.
This is still, this is for, so that we, this is still the joint will executors report, and at the top there, at page 111, for instance, the sale of Kuruwitu Beach Resort cottages and Olive Gardens Hotel was done after beneficiaries were appraised in the meeting of 24th June 2023, cited herein before. Significantly, the beneficiaries themselves in their meetings with one of the executors, underline one of the executors, approved the sale of Kuruwitu Home Resort to one of them, underline one of them,
who is
also an executor. Underline who is also an executor.
Who is the executor and beneficiary being referred to here?
The only executor and beneficiary of the late Nderitu Gachagua's estate, as named in the will and as named in this joint report, is one Honorable Rigathi Gachagua.
Where is this property located, Honorable Mutuse?
Vipingo Beach?
Yes.
Should be somewhere in the coast.
Back to page 107 of volume 4. In his response, as the deputy president explained where he got the sum of Kenya shillings 250 million to purchase this property.
In fact, he denies buying the property.
Now to my learned friend, Mr. Wanyama, to prosecute the remaining grounds of the motion.
Mr. Speaker, with your permission, I'll proceed from where my colleague Mudhomi has left. Honorable Mutuse, can you go to ground number 2 of your motion?
We'll be there shortly.
I think that's page 10 of volume 1.
Here we are.
Yes, what is the nature of this ground? What are you complaining about?
We are complaining that the Deputy President has on numerous occasions violated Article 147(1), as read together with Article 152(1) of the Constitution of Kenya. And in particular, Article 147(1) provides that the Deputy President shall be the principal assistant of the President and shall deputize for the President in the execution of the President's functions. While Article 152(1) of the Constitution states that the Deputy President is a member of the Cabinet. And in particular, through Cabinet communique, as you are aware, after every time there is a Cabinet meeting, there is normally a press release that is released. And we were aware of a decision of the Cabinet of the 30th April 2024, where the Cabinet passed a resolution to evacuate members of the public for their own safety from the 30-meter riparian zone of the Nairobi River.
Yes.
And when that decision was made, insofar as I understand processing of business in the Cabinet, the Deputy President sat in Cabinet. The Deputy President is one who chairs Cabinet subcommittees which process business before going to Cabinet. And therefore, to my own understanding, he was fully involved in the making of that decision. However,
okay, just to cut you short because of time, the allegation is that the Deputy President has been undermining the President.
Yes.
Do you have evidence in your motion that support this allegation?
Yes, I have evidence.
Which evidence is this?
The evidence is in respect of the Cabinet resolution regarding the evacuation of the riparian, of the settlers around the riparian area, in that area, and our evidence is contained in the affidavit of Ms. Mercy Wanjau.
Where is this affidavit of Mercy Wanjau?
The affidavit of Mercy Wanjau is to be found on page 78 to 80 of volume 1.
Has the DP admitted these allegations?
Yes, the DP has admitted the allegation to say there was a Cabinet resolution, but he went against it.
Where is the admission contained for purpose of the answer? The admission by the Deputy President?
If you look at paragraphs 10.1.1 and 10.1.3 of the DP's response.
Yeah.
Volume and page.
Volume 6, page 19 of 534. Paragraph 10.1.1, he says as follows. The Office of the Deputy President has undertaken extensive engagement with all parties in regard to the Cabinet decision on eviction, which I fully support, including the Nairobi River which is an entity under the ODP.
Okay. I think we can hold. We can stop there. So, yes. In your opinion, as a move of the motion, can the government of Kenya function if the deputy president and the president are not reading from the same page?
It will be very difficult for the government to function and to deliver effectively to the people of Kenya when the two highest office holders are reading from different scripts, and especially when the deputy president, for political expedience, would disown decisions of the cabinet in a meeting that he sat through to make a decision.
Yeah, thank you very much. Now, have you annexed any videos to prove this allegation?
Yes, indeed.
Video number?
We have annexed video number 10. Video number 10.
Video number 10.
And also video number 10.
What does video number 10, what is it all about?
Maybe they can play it for honorable senators to see for themselves.
Can you play video number 10 briefly, Mr. Speaker?
Watu ya Kayole, tangu mtupatie nafasi ya uongozi, sijapata nafasi ya kuja kusema asanti. Nataka kutoka kwa roho yangu, watu ya Kayole, asanteni sana. Mimi najua nimeona iko shida ya watu ambaye walibomolewa, na nitapanga na mheshimiwa Meja Dong wakuje ndio tukue na nafasi ya kuongea.
Let us not have a war with wananchi. Tusipigane na wananchi wale walituchagua. Let us be empathetic. Let us, if people must move, let there be an engagement. And let people get adequate notice so that they can prepare for their next life ahead. You can't wake up one morning and terminate people's life. Let us not have a...
Mr. Speaker, sir, we can stop there because of time. The video has been submitted as part of the evidence from the National Assembly. Honorable Mutuse, let's go to ground number, allegation number 3. Is it all about? What is your complaint in the Senate? In ground number 3.
Our complaint to the Senate is that the Deputy President...
Why do you say so, briefly?
We say so because there was a lawful decision by the City County of Nairobi about...
Which is this? Have you submitted any video evidence to support this allegation that the Deputy President has undermined the devolved government system, especially the current government of Nairobi?
Yes, video 12 and video 13, where members of the Senate shortly will see that the Deputy President went to Wakulima Market and incited members of the public not to obey lawful directives of the City County of Nairobi. We have also, as part of our evidence, annexed the sworn affidavit of Mr. Johnson Sakaja, the governor of Nairobi, with averments to that effect. This is at page 81 to 85 of our volume 1.
Okay. I think the video is part of the evidence. It's part of the record. So why do you complain about this in the Senate? Why are you complaining?
The senators want to see the video, want to hear, see and hear the video.
Can we play video 12?
Nairobi Governor Johnson Sakaja appear headed for yet another round of an influence contest of the capital city, with the Deputy President putting the governor on notice over the alleged mistreatment of traders in the city. And as Citizen TV's Melita Olatenges reports, the latest rupture in the relations between the two have been compounded by the broader tribulations of Gachagua, who sees himself as being sidelined by the Kenya Kwanza State House.
2 years ago, downtown Nairobi, in the thick of the campaign trail, and fast forward to this on Friday. In the same style and fashion, he returned to Marikiti, heightening the standoff with Sakaja over traders' relocation. Gachagua says he made a promise that he holds dear but the governor seems to be having a different vision for the county.
Mimi siwezi laumiwa ati watu ya mlima ni wengi hapa Marigiti, kwa sababu hiyo ni Mwenyezi Mungu aliamua. Na hao watu ya mlima wanasema walikuwa wengi, wakikupigia kura kwa nini ukulalamika ni wengi?
That they can micromanage the county of Nairobi from anywhere. No one should imagine that we will suspend devolution in Nairobi from anywhere.
A stop.
So Honorable Mutuse, is that act by the Deputy President impeachable?
It is impeachable in the sense that the two levels of government have been assigned their roles and their functions under Schedule 4 of the Constitution.
Yes.
And the Constitution and Article 6 requires that the two levels of government, much as they are interdependent, they also respect their functional independence. And that if the county government makes a decision, it is upon them to implement that decision. You would realize, much as Nairobi is the capital city of Kenya, cosmopolitan, when the Deputy President went there, he addressed Kenyans in his native language.
Is it compatible with the status of Deputy President, these core issues at a marketplace like this?
It is not consistent. The expectation was that through the intergovernmental relations framework that is already established in law, there would have been a committee, and also IBEC would have exercised his responsibility under the law and those responsibilities,
yes,
to call a meeting with the City County of Nairobi to deliberate on those issues if indeed there were complaints from the citizens of Nairobi in a manner that is consistent with the formal running of a government.
Okay. I think because of time we can move to allegation number 4. Are you there? Just go to your motion, allegation number 4. What is it all about? Explain briefly to the honorable senators. Allegation number 4, I believe it's at page 14 of your motion.
1 minute. Yes, here we are. Now, our ground 4, Mr. Speaker and honorable senators, is gross violation of Article 161 of the Constitution, specifically undermining the institutional and decisional independence of judges.
Hold on, Honorable Mutuse. What do you understand by the word gross? You're using it in a context, and I think it is important you explain briefly. What do you understand by the meaning of the word gross?
My understanding of gross violation of the Constitution, I don't know whether I will be speaking in my knowledge as a lawyer or just as a...
Just give your opinion. What is gross? It goes into the answer there.
I think gross violation of the Constitution, the best would be found in the Wambora decision.
Okay.
The Wambora decision did define what gross violation of the Constitution means.
Yes.
And it is said it is the violation of Article 10, Article 1, and several articles of the Constitution. I do not have the particular citation, but to my mind, I think it's paragraph 46 of that decision.
Okay. So let's go back to allegation number 4 that you're complaining about in this ground. In summary.
We are complaining that the Deputy President did threaten in a manner that displayed personal vendetta the person of Esther Maina, a judge of the High Court of Kenya. The reason for threatening her with filing a petition for a removal from office, particularly in relation to a decision that she made in a case that was involving the Deputy President by finding that assets to the tune of cash 202 million that were held in his company's accounts were proceeds of corruption and money laundering. And for making that decision against the provisions of Article 161, threatened the Justice Maina with corruption and with removal from office.
Yeah, this decision that you're talking about, Justice Maina's decision, where is it? You can, the honorable senators. This decision, the judgment of Esther Maina.
Senators, Mr. Speaker, honorable senators, in our volume 2A at page 60 to at page 60 all the way to page the judgment of the Honorable Judge Esther Maina, where many of the companies that we have allegations are listed here as companies that are conduits of corruption and money laundering.
Which companies are these in the judgment? Just maybe you can name a few of them so that we are more specific for the answer.
You have heard us talk about Crystal Kenya. Crystal Kenya is here.
You're saying Crystal Kenya is mentioned in the judgment?
Yes, this is on page 64. And many, many others. So that with Wamonyoro Investments, you have heard us mention Wamonyoro Investment. Wamonyoro is mentioned here several times.
So what is the conclusion by the judge in that judgment, the decision that you are complaining about?
The judge, the originality motion is granted in terms of prayers 2. This is page 77 of 123 in our volume 2A. That a declaration is hereby issued that the following funds are proceeds of crime and therefore liable for forfeiture to the state. And they are listed there, 165 million held in a certain account at Rafiki Finance Bank, 35 million in the name of Rigathi Gachagua, 773,000.
How much in total did the judge find to be money that Rigathi Gachagua at the time had obtained through proceeds of corruption?
An order is hereby issued that the above funds be forfeited to the government of Kenya and transferred to the Assets Recovery Agency, and the amount is about 200 million shillings.
So he finds Mr. Rigathi Gachagua to have obtained 200 million shillings. 200 million.
How he obtained 200 million shillings.
What did the judge do after that finding?
The judge directed that the amounts be forfeited to the government of Kenya through the Asset Recovery Agency, which is the body created under the Proceeds of Crime and Money Laundering Act to take care of money laundering.
Yeah, Mr. Ongoya, for the deputy president who was here, and the family stated that that you have no ground at all to bring this allegation in the Senate. What is your specific complaint in the Senate on this allegation?
My specific complaint is that when a judge in a functional democracy in a country of rule of law like ours, when a judge makes a finding against, and the judges make findings against all of us every day, the civil way of challenging that decision is through an appeal. So you appeal the decision. You do not go to a rally and start threatening judges, because then you create fear, and you create fear in the judges so that they are not able to exercise their decision or independence. You can interfere with financing of the judiciary. You can interfere with many, many other things, but let's not take away the decision or independence.
Honorable Mutuse, do you have any evidence that you've submitted to the Senate to prove this allegation of, you're calling it interference with the independence of the judiciary? Do you have any video evidence, any evidence?
Yes, I have presented video number 14 and video number 15.
I request the video, Mr. Speaker, to be
clips of
Begin the bulletin with the war on the judiciary, where Kenya Kwanza administration is making good on its threat, with the Deputy President Rigathi Gachagua now filing a petition to push for the removal of a judge from office.
Gachagua says he will on Thursday file a petition with the Judicial Service Commission to push for the removal of Justice Esther Maina, who handled an economic crimes case against him in 2022 for alleged corruption and misconduct. Now, speaking in Iten, where he accompanied President William Ruto for a church service, Gachagua told the Chief Justice to first clean up her house by dealing with pending cases with the Judicial Service Commission. Now, in the sustained onslaught against the judiciary, President William Ruto vowed to deal with unnamed government officers he described as incompetent, saying his administration will slay the corruption monster that has reared its ugly head in various arms of government. Chamatai Goin reports.
After Chief Justice Martha Koome invited Kenyans with complaints over the conduct of judicial officers to submit their lamentations to her office, the Kenya Kwanza administration, through Deputy President Rigathi Gachagua, has taken the challenge, with the DP announcing that he will file a petition this week.
Amechallenge sisi tutoe ushahidi. I will lead by example. On Thursday, this coming week at 2:15, I will personally present a petition before Lady Chief Justice Martha Koome against Justice Esther Maina for her removal from the judiciary for misconduct and corruption. Mimi mwenyewe ndio nitaongoza, because sasa unajua sasa si ametuuliza. Sasa tuko tayari, mimi ndio nitaongoza kwa executive.
Gachagua reliving his July 2022 incident where 202 million shillings was seized to the state after Justice Esther Maina ruled the money was proceeds of corruption having been acquired through dubious means.
Huyo judge through corruption declared my hard-earned wealth proceeds of crime without giving me an opportunity to be heard. Against the rules of evidence, where he who alleges must prove. We made an application to cross-examine the investigator, akakataa kwa sababu anajua there is no case. Na evidence tuko nayo vile ilifanyika.
The Kenya Kwanza Battalion hitting out at Koome for being quick to defend judicial officers, some of whom they claim were not beyond reproach.
I think we can stop there. We can stop there. Now, Honorable Mutuse, it looks like in this public forum, statements were generally made against the judiciary. Is that correct? By all politicians who attended?
Yes, it is correct that even others who were there made statements against the judiciary, and there is no problem with that.
Yeah. So what is so extraordinary? Mr. Ongoya said, there's nothing extraordinary about your complaint.
My complaint is extraordinary in the sense that the Honorable Rigathi Gachagua was not complaining about the judiciary. He was complaining about a specific judge for a decision that she made, a finding that she made against him. It was not about corruption in the judiciary. It was not about inefficiency in the judiciary. It was not about how the judiciary runs. It was about huyu judge alisema mali yangu ni mali ya wizi.
Now, in that public statement, the Deputy President says he has evidence on corruption against Lady Justice Maina. In his response filed before this House, have you seen any evidence adduced for corruption against Lady Justice Esther Maina?
I have not seen any evidence to show that indeed he has evidence of corruption influencing the judge to make the finding that the 200 million were proceeds of crime.
Okay. Now, this judgment
which leads me to my conclusion that this is personal vendetta.
What do you mean by personal vendetta?
Personal vendetta is you are here in Senate representing your people, you make decisions in Senate, you make debate in Senate as part of your constitutional mandate. You mention people who are not doing things right, and when you get out there, they threaten you. They tell you, when you say that again in Senate, I'll kill you.
Okay.
I'll get you removed from Senate to create fear. Personal vendetta.
Now, this judgment, which you've said is available at page 60 to 77, and you quoted it of volume 2A of your documents. Could you by any chance know what happened to this judgment?
Yes, I am aware that indeed the Deputy President did appeal against that decision.
Yes.
But on becoming Deputy President, the same was settled through a consent, a compromise, as it would be, and the money was returned to him.
The money was returned to him. Have you seen this consent that was recorded at the Court of Appeal?
Yes, I am aware of the consent.
Okay, you are aware?
I am aware that the consent was not arrived based on the merits or demerits of the case.
Okay.
It was just government bodies, because leadership has changed hands, and the second in command now is powerful. They went to court and they said.
Honorable Mutuse, is there a decision of the Court of Appeal? A decision of the Court of Appeal upsetting or setting aside this judgment and the finding by Lady Justice Esther Maina about
to my understanding, and the lawyers in the House will also have the same finding. There is no decision of the Court of Appeal.
Have you seen any of this response?
Overturning Justice Maina's decision, and therefore Justice Maina's decision remains.
The response by His Excellency Rigathi Gachagua. Have you seen any appeal decision setting aside?
No, there is
any order setting aside the judgment?
The consent is there, but there is no decision.
So in your opinion, does undermining the independence of the judiciary amount to gross violation?
It amounts to gross violation of the Constitution. It will be, remember that we have three arms of government: the executive, the legislature where we sit, and the judiciary.
Is it proper for the Deputy President of the Republic of Kenya to make this kind of attacks? Is it proper in your opinion?
It is not proper at all.
Okay. And what, in your, again, to just wrap that point up, what channels...
Counsel, before you get there, you refer to a consent. Is it contained in any of these bundles? The senators would wish to look at that consent.
Honorable Mutuse, you said you have seen a consent. You are aware about it. Have you seen the consent?
It is not filed in our documents, but in my ordinary course of business, I am aware of the consent.
Okay.
If it becomes necessary, the Senate has the powers to recall it. In fact, it is a public document because it is reported under Kenya law reports.
Fair enough. Let's go to allegation number 8 because of time, so that we don't take a lot of time and finish our time. What is the substance of your allegation number 8? Briefly, ground number 8.
Ground number 8 is that there are serious reasons to believe that His Excellency Rigathi Gachagua has committed crimes under Section 132 of the Penal Code and Section 129 of the Leadership and Integrity Act. And basically here, it is on two folds. The two sections that we have cited, Section 132 of the Penal Code and Section 29 of the Leadership and Integrity Act, speak to state officers misleading the public, spreading falsehoods. And on the issue of Justice Maina, as we have shown evidence, it was personal vendetta because the Deputy President was attacking the judge based on a decision the judge had made. On the second one, in terms of the particulars, His Excellency Rigathi Gachagua recklessly and unmindful of the high calling and dignified status of the office of the Deputy President of the Republic, of membership to the National Security Council and Article 240 of the Passer County, and publicly made sensational statements against the National Intelligence Service, an essential national security organ, its Director General.
And also, you can hold on there. Do you have evidence to prove these allegations about a live television statement in Mombasa by the Deputy President? Do you have any evidence before this House?
Yes, we have annexed our video number 15.
May I request we play video number 15, please, Mr. Speaker.
Where did the rain begin to beat us? Where did we stop listening to the people? President William Ruto and I were the darling of the Kenyan people. By listening to them, by engaging them. And as a government, we have established institutions to ensure we not only listen to Kenyans, but also genuinely understand their concerns. We invest significant resources in these institutions, particularly the National Intelligence Service, for this purpose. It is clear there has been a failure in the intelligence and advice we are receiving, particularly concerning crucial government policies. The President of the Republic of Kenya today has admitted that it has come to his attention that the people of Kenya did not want anything to do with the Finance Bill 2024.
Honorable Mutuse,
President,
maybe we can...
There is an important
okay.
has now agreed that we need to listen to the people. Yeah. And I sympathize with my boss, President William Ruto, because this information was not available to him. I know President William Ruto. Had he known 2 months ago that the people of Kenya did not want anything to do with Finance Bill 2024, he would not have asked his parliamentary party to push it through. Yet, we have an organization paid by the public to give him and government such information. And that is where the problem is. We have a dysfunctional National Intelligence Service that has exposed the President. National Intelligence Service briefed the President 2 months ago about how the people of Kenya in advance.
The National Intelligence Service slept on the job. And the problem is, the Director General of the National Intelligence Service, Nurdin Haji, was a junior officer in the National Intelligence Service before he was appointed as DVP. When he was appointed to the office of the Director General, because of inferiority complex, he chased away all the people who were senior to him when he was in the service, therefore crippling the capacity of that service and making it dysfunctional. 3 directors were chased away and reassigned to desk jobs in
Mr. Speaker, sir, we can pause it at that because of time. We've captured the parts. Now, Honorable Mutuse, the Deputy President recently addressed a press conference where he rubbished this allegation, said it's pure hogwash. What is your specific complaint against the Deputy President in this allegation?
2 specific complaints. 1, the Deputy President is a member of the National Security Council. And if he has any complaints against the National Intelligence Service,
yes,
who also sit in the National Intelligence Council, he can raise those concerns there. So that we professional leadership.
You mean the National Security Council?
The National Security Council created an Article 240 of the Constitution.
Yes.
And the Deputy President has forum. And like all other ordinary citizens, senators included, us, we can complain out there because we don't have an official institutional forum. The Deputy President has forum where he can raise his concerns. Number 2, this was a time of monumental crisis in the Republic of Kenya. And the statements were sensational and they would have made Kenyans to believe that our security organs are not functional and would have easily led to citizens running amok and the Republic getting torn apart and our national fabric getting destroyed completely. But even more importantly, I had learned Counsel Ongoya refer you to your oath of office. And I would wish that he also refers his client to the oath of due execution of office that he did swear. In the oath of due execution of office that the Deputy President took on ascension of office, it states as follows, that I will not directly or indirectly reveal such matters as shall come to my knowledge in the discharge of my duties and committed to my secrecy, emphasis, secrecy. He has said that officers of the National Police Service have told him in confidence that they had not received advance intelligence reports. That is what was contemplated by this oath of due execution of office, what Senior Counsel Orengo called addressing fears. That if a matter is committed to you as a state officer in secrecy, it must remain in secrecy. If you take it to a public press conference, then you have gone against your oath of office, and that is an impeachable offense.
This oath of office that you say the Deputy President takes, is it anchored in any clause of the Constitution?
Yes, the oath of office is in the 3rd schedule of our Constitution and therefore part of our Constitution.
Can you read Article 148(5)(a) of the Constitution?
Even to begin with, under Article 74 of the Constitution, before assuming a state office, acting in a state office, or performing any functions of a state office, a person shall take and subscribe the oath or affirmation of office in the manner and form prescribed by the 3rd schedule or under of Parliament.
Okay. And what about Article 148, paragraph 5A? What does it say?
Article 148, paragraph 5A.
Yes, yes.
It says the Deputy President-elect assumes office by taking and subscribing the oath of affirmation of allegiance, affirmation for the execution of the functions of office as prescribed
in the third schedule. So it is a constitutional issue.
Finally, the Deputy President in his press statement the other day, he said, even in other countries, the US, stable democracies, it's not uncommon to see heads of intelligence institutions being attacked or criticized by public officers. What is your comment about that specific remark?
Even in our country, it is not uncommon, but it depends on who is doing it. The Deputy President of the Republic of Kenya cannot behave in a manner that disparages the institutions of the state that he was elected to superintend, especially so when he has official institutional forum to raise those concerns.
Is there a forum where the Deputy President can conveniently raise these issues
without undermining public confidence in the security system and public trust in these institutions that are paid by the taxpayer?
I have said earlier, under Article 240, the membership of the National Security Committee is number one, the President, and number two, the Deputy President.
Okay.
And the National Intelligence Service is a member.
And therefore, that can be canvassed behind closed doors in a formal way and a decision made so that we do not break down our institutions. Instead, we empower them.
Which article of the institution are you saying Security Council is established?
Article 240, if my mind serves me right.
Okay.
And we can read it if we have time.
The other explanation by the Deputy President is that these agencies are accountable to the civilian authority and therefore not immune to criticism.
Article 240, establishment of the National Security Council. There is established the National Security Council. The council consists of the President, the Deputy President, so is a member by dint of Article 240. Subject to civilian authority. Because of Article 1.
Okay. Yeah, because of time, let's go to the last allegation. Last allegation. That's ground number 11. Are you there?
Yes, I'm there.
Okay. Can you explain to the senators your specific grievance?
It is we are saying that the Deputy President has committed gross misconduct by bullying state officers.
What's specific ground on that gross misconduct that you want?
We are saying that bullied Kenya Medical Supplies Agency officials
into awarding a tender for the supply of mosquito nets to Crystal Limited, his proxy company, that it submitted an irregular bid bond with the sole intention of fraudulently acquiring public property. That His Excellency, so that we can paraphrase, KEMSA advertised a tender funded by the Global Fund, which is one of our major development partners in terms of delivery of healthcare in Kenya.
Yes.
The tender was valued at about 3.7 billion. At the time, the procurement process got botched up, and Senate would take notice that at that time, the peers in charge of public health and the CEO at KEMSA were dismissed by His Excellency the President.
Yes.
And then an acting CEO was appointed, and the acting CEO also saw an affidavit to this regard. And the problem here was that there is a company, an Indian-based company, called Shobika.
Shobika.
Bringing in a company that was not. In the evidence of the Deputy President, this company called Shobika is represented locally here in Kenya by a company called Crystal Kenya. And that is by the admission of the Deputy President himself in his own response. And Crystal Kenya is the company that we have demonstrated all the way from Nyeri to Malindi to Kilifi was vehicle that the Deputy President had to launder money. So this company has an agency agreement with Shobika to represent them locally. And what happens, the evidence that we have placed on record is that when Dr. Andrew Mola is appointed the new CEO of KEMSA, at that time, investigations are going on into the irregular procurement of the 3.7 billion mosquito nets. And then one of the issues of interest in that tender is how Shobika submitted their bid bond, because the main complaint was that they submitted their bid bond outside the tendering period. So when investigations are going on, the Deputy President, who admitted live on television, called Dr. Andrew Mulwa, the acting CEO of KEMSA, and told him, I have sent my people, please give them that bid bond. And he said he did it because the people were wondering. And then we have annexed messages, WhatsApp excerpts, in the affidavit of Dr. Andrew Mulwa, 67 to, in the volume, if you go to volume 1, page 67 to page 8 to just briefly, so that we are factual. All the way to page 77, we have annexed the affidavit of the witness affidavit of Dr. Andrew Mulwa.
Okay.
And on it, we have also exhibited SMS messages.
Honorable Mutuse.
Yes.
I think we've seen the affidavit. You said it's at page 67, eh?
Yes, page 67 of volume 1.
Yeah, and you've said the Deputy President interfered with this, attempted to interfere with this tender process, eh?
It is evidence.
Where is that evidence so that we can...
Order, honorable senators. Senator Boni, please take your seat. Now, honorable senators, I did suspend the sitting of this House to allow Senior Counsel Paul Mwite for the Deputy President, one, to locate his client and report back at 5 so that we may proceed with these proceedings. Senior Counsel Paul Mwite, you may now inform the House so that we proceed.
Mheshimiwa Speaker, I'd like to inform honorable senators that I've been able to contact the doctors at Karen Hospital. There are a number of doctors, a team of doctors, who are looking after the Deputy President. Because of his condition, I was not able to directly talk to him on the advice of his doctors. He said he must have complete rest for the time being. I was, however, informed by his doctors that he is currently suffering intense chest pains. I did not want to inquire beyond that, Mheshimiwa Speaker. But just in order to perhaps save the time of this Honorable House, let me, as I sit down, invite Mr. Speaker and the House to look at Article 145 of the Constitution, sub-Article 6. Mheshimiwa Speaker, sub-Article 6 of Article 145 says, if the special committee reports that the particulars of any allegation against the President, of course it applies for the Deputy President. If you go to B, have been substantiated, the Senate shall, after according the President an opportunity to be heard, vote on the impeachment charges. Mheshimiwa Speaker, we are aware that this Honorable Senate made a decision to hear the charges in plenary, so that what we are doing in these proceedings, I would suggest and submit we are proceeding under sabbatical 6B. And under sabbatical 6B, this House, by the Constitution, is obligated to accord the Deputy President an opportunity to be heard, which is why Rule 11 of the standing orders of this House specifically provides, Rule 11, where the National Assembly or the President chooses not to appear. And I would like to submit that the Deputy President has not chosen not to appear. The choice of the language chooses to appear in Standing Order number 11 is to be read with the Constitution Article 145, Sabbatical 6, which obligates this Honorable Senate to accord the Deputy President an opportunity to be heard. In your hands, Mr. Mheshimiwa Speaker and Honorable Senators. I would suggest Article 145, the sabbatical, I've read sabbatical 6B, doesn't have a time limit of 10 days. Give the Deputy President, in the interest of justice, given the weight of removing a Deputy President, a couple of days. A couple of days ahead in mind, up to Tuesday. We should be able to know when the Deputy President is able to come and defend himself. I thank you.
Counsel for the National Assembly.
Mr. Speaker, sir, permit me to start by registering our greatest sympathies and empathies and from the team, the National Assembly. Of course, issues to do with health are issues that are beyond our control. Mr. Speaker, sir, that said, we also would want to be cognizant of the fact that we are dealing with a constitutional moment. We are dealing with an item whose timelines are prescribed within our Constitution. Mr. Speaker, sir, contrary to what learned senior counsel, Mr. Paul Mwite, would want to persuade this House to believe, the proceedings before this House have not been the subject or have not been transacted pursuant to Article 145(6). Mr. Speaker, sir, on the 9th of October this year, this House did sit, did pass a resolution pursuant to the provisions of Article 145(3). Mr. Speaker, sir, pursuant to that resolution, there was a Gazette notice which very clearly indicates that this House was not going to determine that the matter at hand from a committee perspective, but that the whole House would then be determining the matter. It then follows, Mr. Speaker, sir, that the provisions of Article 145(6) would not be applicable. Mr. Speaker, sir, in the same Gazette notice, you did Gazette the 16th and 17th of October to be the days assigned for the hearing and determination of the motion that is before you. That said, Mr. Speaker, sir, we appreciate the place of fair hearing and an opportunity to be accorded the chance and the facilities to be able to defend one's self in a motion such as this. Mr. Speaker, I would want to add that the opportunity to be heard does not have to be oral. The rules of this House permit that parties appearing could elect to be represented, they could elect to come in person, they could file documents. Mr. Speaker, sir, His Excellency the Deputy President has participated robustly in the proceedings both before the National Assembly, where they filed a very, very detailed replying affidavit and a response. Mr. Speaker, sir, if my memory serves me right, let me just make a quick reference. Before the National Assembly, His Excellency the President did file a response dated the 8th of October 2024. When the proceedings before this House began, His Excellency the President, the Deputy President again filed a very robust response dated the 12th of October 2024. Mr. Speaker, sir, up to this point in time, His Excellency the Deputy President, together with his team, have had a beautiful opportunity to present their case. They have had an opportunity to cross-examine in great detail all the witnesses that we presented before this House. If anything, Mr. Speaker, sir, if any prejudice were to be occasioned in the course of this, hearing this matter, that prejudice would be on us, because our expectation would be that His Excellency the President would be able to attend and avail an opportunity for the National Assembly to cross-examine him. Mr. Speaker, sir, taking into account the circumstances that we find ourselves in, having also very keenly heard learned senior counsel speak, matters held are not matters to be taken lightly. On the same tone, Mr. Speaker, sir, matters held cannot be given timelines. There cannot be certainty that if an adjournment were to be given even for 1 week, then there is clarity and certainty that we'll be able to proceed on that assigned day. Mr. Speaker, sir, we would urge that we borrow practice that has accorded to other similar organs created by the Constitution. I have the courts of law in mind. Mr. Speaker, sir, because I'd earlier on submitted that Article 50 provides for an opportunity, provides for the right to fair hearing, and that fair hearing does not necessarily have to be oral, we have had practice in our Supreme Court where dealing with some of the most important decisions of our lifetimes, including decisions arising from presidential elections, have, in all the elections that we have had parties file submissions and their documents, and that their advocates have had an opportunity to appear before the courts to highlight those documents and pleadings that have been filed. In this occasion, because His Excellency the Deputy President has had an opportunity to present all the material that he ought to or he wanted to present, and also had the opportunity to cross-examine all the witnesses that he wanted to cross-examine, all that is left on their side is highlighting. On our part, Mr. Speaker, sir, the part of the National Assembly, so that then we are able to give progress to this matter, we are willing to take the painful decision to forego the cross-examination of His Excellency the Deputy President and only proceed with highlighting submissions in relation to the documents that we have filed before this House. it is our humble view that no to His Excellency, the Deputy President. Mr. Speaker, sir, we urge that if I heard my learned senior colleague, Mr. Paul Mwite, Senior Counsel, well, he seemed to have been imploring this House to consider adjourning. Mr. Speaker, sir, let me end by drawing the attention of this court to Rule 12 of the proceedings, the rules governing the proceedings currently underway. Mr. Speaker, sir, Rule 12 of those rules dictates that once the hearing has commenced, it shall proceed up to the end. It does not provide for an option for the House to adjourn. If that is the dictate, Mr. Speaker, sir, of the rules governing the proceedings before this House, we urge that being a country, being an organ of a constitution that is that is controlled by the rule of law and the Constitution, you direct that we proceed with the hearing as had been planned. I am most obliged. Mr. Speaker, sir, just before I leave the ground, maybe I would want to invite my leader, Mr. Honorable James Orengo, Senior Counsel, to also just add one word before you give your directions. I'm most obliged.
Mr. Speaker, just briefly, in these proceedings, we are governed by Article 145. And there is a very unique provision in Article 145 that you don't find in legislations to do with even litigation in the courts. But because the makers of this constitution knew that these proceedings are time-bound, there is under Article 145, Subarticle 5, a very important provision. And I think that article is not there for cosmetic value. That article is there to deal with a situation like we find ourselves in, because the makers of this constitution knew that when processes are time-bound, they must be a safety valve. Article 145, Subarticle 5, which applies mutatis mutandis in relation to the removal from office by way of impeachment of the Deputy President, states as follows. The President, and for that matter, it should be read, the Deputy President, shall have the right to appear and be represented before the special committee during its investigation. Now, the point that I want to make, that not in a lot of legislation you find the right to be represented highlighted, because the Deputy President can elect to be represented either by his advocate or by him appearing in person, or having both the Deputy President and his advocate to appear. Now, I want to put before the Senate, because a lot of you have this problem a lot of time during the elections. If, in accordance with the election law, you are required to subscribe your nomination papers on a certain day, and you fail it, you're running for president or deputy president, and you're told that you must present your nomination papers on a certain day, as it is there in the law, would you feign sickness and fail to represent your nomination papers on that particular day? And I can tell you, if you fail to do so, the law will not give you any accommodation. You'll be out, and there are a lot of decisions on this matter. I want to talk to this Senate very frankly, that Senior Counsel Mwite was basically giving evidence. He has not told us where, or if he has told us, the medical institution where the Deputy President is. But for the Deputy President to fail to bring evidence, credible evidence before the House that has been admitted, even that evidence that has been admitted to a medical institution, we don't have it. We will rely on the evidence from my senior counsel, Paul Mwite. That is evidence. But in practice, I can say without a fear of contradiction, there are many times where people are represented even in medical documents, and later on they've been found to be fake, if I may use that word. I think the thing that the Deputy President should have done, we should have had one of the doctors here, at least to tell us about his admission and about his condition, because up to 1:15, the Deputy President was here. He was not evacuated from here in an ambulance. And if I can give evidence from the bar, he went to his office, and again, there's no evidence that he was evacuated in an ambulance. He went to Karen Hospital in himself to check at the hospital. So I think our constitutional duty is to live by what the Constitution requires of us. The greatest prejudice, for me, I was looking forward to cross-examine the Deputy President. But unfortunately, the story that has been told does not include cross-examination of the evidence of the Deputy President, which is on record. But because we are time-bound, and as my London friend Eric Gumba said, we are prepared to go by the evidence in record. The prejudice is to us. The sickness of the Deputy President is affecting us more because we would want to cross-examine him. But he has evidence in record which we cannot test by the way of cross-examination. And there's no assurance that on Tuesday, the Deputy President would be here. Finally, we can also say from here that there are many cases that have been filed all over, including in Malindi today, that has to do with the proceedings that are going on here. So I am in a position to say that this health condition in which the Deputy President is, and I sympathize, may be opportunistic in the absence of medical evidence from a doctor. It may be opportunistic. And I saw him when he came in. I'm not a doctor, but there was nothing to suggest that he was in the condition that Honorable Counsel has been talking about. So do the senators now turn into a jury to make a decision on the basis of evidence presented from the bar by senior counsel without no documentary proof of where the Deputy President is and what ailments is suffering for? I think the more important duty for this Senate is to comply with the Constitution. And we urge you to comply with the Constitution and proceed with the hearing of this impeachment proceedings. Thank you.
Senior Counsel Paul Mwite.
Mheshimiwa Speaker, honorable senators, we all live in Kenya, and I would like to make this submission. These capture every word uttered accurately. so that if I was found tomorrow to have lied to these senators, sanctions can be brought on me. And I would have thought that that fear of telling a lie to this honorable Senate, to me, is more powerful than even bringing a medical report. We've had many medical reports generated outside hospitals. We see them in courts almost on a daily basis. Mheshimiwa Speaker, you will remember the rush that was there when I was asking to be given up to 5 p.m. And it was a rush. Was I to fail to come back to this honorable house at 5 p.m. waiting for a medical report when the doctors there are busy attending to their patient, the Deputy President? Medical reports I can bring. If I've told lies, that is something that can be established. And my learned friend, Mheshimiwa Honorable Orengo, talks about giving evidence from the bar. When I was learning, they are seated down when he's giving evidence from the bar about some cases filed in Malindi that I'm not aware of. Perhaps he should have given us a copy of that. Mheshimiwa Speaker, Article 145, Sub-Article 6 is clear, and I do not want to take time of this august House, Senate. Going back to it, it applies, and I would plead with you and with honorable senators to give us until Tuesday to see whether the Deputy President will be well enough. No one decides when to get sick and when not to get sick. I am sure many honorable senators here will have a story of their shock because of having spent an evening with somebody, then the following day they hear that the person is gone. Yet that person was looking good and healthy. Let's be humane. Let's be compassionate. Tuwe na utu kidogo. Tuesday, the heavens are not falling down to join with the earth. I thank you, Mheshimiwa Speaker.
Senior Counsel, Paul Mwite. There is a hypothetical question that was raised by Senior Counsel Orengo. Assuming, and it's just an assumption, assuming the Senate is inclined to grant your client up to Tuesday, and by Tuesday, your client is unable to attend Senate, what then will be the way forward?
Mheshimiwa Speaker, I would submit the best thing is for this honorable House, honorable Senate, to make a decision on facts rather than assuming what may or may not happen. Point number one. Point number two, Mheshimiwa Speaker, is the importance of honorable senators seeing with their own eyes how a witness withstands cross-examination. There are many times when different impressions will be given by a written document, and yet when cross-examination takes place, individuals change their minds. One can only make a decision on whether this witness is believable or not believable when they see his demeanor in person. So there's nothing to replace orality through cross-examination. There are many witnesses whose statements will be impressive, and yet when they begin to give evidence orally, that impression changes completely on the mind of the jury. The Deputy President wishes to subject himself to cross-examination, wishes under oath to deal with the evidence given adverse to him by witnesses here, so that honorable senators can have an opportunity of making a decision. Is it the Deputy President we shall believe, or is it those other witnesses? That opportunity can only come through orality and through cross-examination. So what this House elects to do, that decision, this House, Mheshimiwa Speaker, they will make on Tuesday. I am always an optimist. So I am living in the belief that the doctors may be able to put whatever is wrong with the Deputy President back in place so that he can be here on Tuesday, Mr. Speaker. If he's not here, let that decision of what this Honorable Senate will then do be made on Tuesday. That is a humane way of going about a matter about no one had control of. I thank you.
Now, honorable senators, having listened to the counsel for the Deputy President, as well as the counsel for the National Assembly, I need to consider those arguments and give my considered ruling in this matter. I will therefore suspend for 5 minutes. 5 minutes. 5 minutes, and I'll be back. Arise.
You are watching live pictures from the floor of where the House has briefly adjourned. The Speaker of the Senate is expected to come back and give a ruling on the way forward. The council representing the Deputy President has requested that the team be given until Tuesday so that the Deputy President can be given the opportunity to be heard before the Senate takes a decision on the impeachment motion that was forwarded to the Senate by the National Assembly. The National Assembly, through its council, has submitted to the Senate that the evidence that was adduced by the Deputy President in writing be considered in this matter. The National Assembly also, through its legal counsel, has also told the Senate that it is willing to forego the cross-examination of the Deputy President, who was to appear as the sole witness in this historic trial in the Senate. The National Assembly did forward to this House 11 grounds of impeachment, which it believes that it has presented enough evidence to warrant the impeachment of the Deputy President. Among the grounds that the National Assembly did advance is the gross violation of Article 10, Sub-Article 2A of the Constitution, and B and C, Article 27, Sub-Article 4, Article 73, Sub-Article 1A, and Article 2B of the Constitution. The National Assembly, in its submission during this trial, did say that the matter of constitutional compliance, the Deputy President of the Republic of Kenya, who is the principal assistant to the President of the Republic of Kenya, is required to promote constitutional core values such as peace and unity of all Kenyans in the context of ethnic, cultural, and religious diversity, patriotism, national unity, rule of law, democracy and participation of the people, equity, social justice, inclusiveness, equality, human rights, non-discrimination and protection of the marginalized, and good governance. It will also respect and uphold representation of Kenya's multi-ethnic and culturally diverse society through the promotion of equality and affording equal opportunities to all Kenyans in appointments to the public service and allocation of public resources, and to promote and implement public policy decisions that do not discriminate against any Kenyan based on conscience, ethnic or social origin, language or birth. In its argument, the National Assembly said that on diverse dates throughout the last 2 years, His Excellency the Deputy President has persistently made utterances threatening to discriminate, exclude and unlawfully deny sections of the people of Kenya and regions of the Republic of Kenya equal opportunities for public service appointments and allocation of public resources. Besides, the utterances are highly inflammatory and insightful and significantly undermine national unity and the peaceful coexistence of Kenya's diverse communities. In forwarding its evidence to the Senate for the purpose of this trial, the National Assembly did illustrate instances where it believes the deputy president has been on record committing the said violations. Ground 2, gross violation of Article 147, Sub-Article 1, and Article 152, Sub-Article 1 of the Constitution. The National Assembly states that Article 147, Sub-Article 1 of the Constitution provides that the Deputy President shall be the principal assistant of the President and shall deputize for the President in the execution of the President's functions. In addition, Article 152, Sub-Article 1 of the Constitution states that the Deputy President is a member of the Cabinet. The National Assembly argues that on various dates throughout the last 2 years, His Excellency the Deputy President undermined the President and the Cabinet and the effective discharge of the national government's executive mandate by making unilateral public statements that were inconsistent with policy positions collectively adopted by the government. Under this charge, the National Assembly has moved to illustrate instances and occasions in which it deems the Deputy President to have committed this offense. That on or around 30th of April 2024, the Cabinet passed a resolution for the evacuation of people residing along the Nairobi River. Shortly after that, His Excellency the Deputy President made a public statement opposing the Nairobi River riparian evacuation orders, which the National Assembly argues that the Cabinet had sanctioned for public safety and climate change mitigation. His Excellency the Deputy President made contradictory public statements despite being a member of the Cabinet and being assigned the function of superintending the Nairobi River riparian evacuation order. In addition, the National Assembly argues that His Excellency the Deputy President has on several occasions throughout the last 2 years made public statements contradicting the President on critical matters of governance and the exercise of the President's functions as a symbol of national unity. It has also tried to illustrate that in March 2023, at a public forum in the Nyanza region, the President said Kenya belongs to all, notwithstanding how people voted in 2022 general elections, and that he would ensure the government does not discriminate against anyone. However, His Excellency the Deputy President, speaking after the President at another public forum, contradicted him by saying that Kenya is a company in which the provision of government services is based on shares. That His Excellency the Deputy President has made numerous other utterances at public forums where he publicly restates the division narrative that Kenya is a company in which the rights of citizens are based on shares determined by how various ethnic communities voted in the 2022 general election. The National Assembly argues that the Deputy President's unilateral, divisive, and insightful public statements are impeachable offenses to the extent that they undermine the effective discharge of the national government's executive mandate, that they violate the doctrine of collective responsibility, and that they are equivalent to insubordination of the President, which is incompatible with his constitutional status as the principal assistant to the President of the Republic of Kenya. Ground 3, gross violation of Article 6, Sub-Article 2, Article 10, Sub-Article 2A, Article 174, Article 186, Sub-Article 1, Article 189, Sub-Article 1, and the 4th Schedule to the Constitution. This, quote-unquote, undermining devolution. The National Assembly, in its submission in this trial, argues that Article 10, Subarticle 2A of the Constitution provides that devolution is a fundamental national value and principle of governance. In addition, Article 6, Subarticle 2 of the Constitution provides that government at the county and national levels are distinct and interdependent and shall conduct their mutual relations based on consultation and cooperation. These provisions, the National Assembly argues, that are supplemented by Article 189, Sub-Article 1 of the Constitution, which provides that governments at each level shall perform and exercise their powers in a matter that respects the functional and institutional integrity of government at the other level. Under paragraph 7A of Part 2 of the 4th Schedule to the Constitution, county governments are responsible for trade development and markets as an exclusive function. Moreover, the Deputy President chairs the Intergovernmental Budget and Economic Council, which the National Assembly argues is an essential organ for consultation between the two levels of government. In its submission before the Senate, the National Assembly, through its legal representatives, say that on or around 20th September 2024, His Excellency Rigathi Gachagua, recklessly unmindful of the high calling and dignified status of the office of the Deputy President of the Republic, unlawfully interfered with the running of Nairobi City County Government by holding a public rally in which he incited citizens against lawful directives of the Nairobi City County Government on the planning and relocation of markets. Further, the National Assembly argues that His Excellency, the Deputy President, publicly disparaged the leadership of the Nairobi City County Government and its decisions. Moreover, the Deputy President has interfered with the proper discharge of county government's constitutional functions regarding alcohol and control and regulations. His Excellency, the Deputy President's insightful and demeaning public statements and conduct are impeachable offenses to the extent that they undermine devolution. This is according to the submission by the National Assembly, and that they undercut the functional and institutional integrity of county governments. They unjustifiably vilify and ridicule the leadership of county governments, especially the Nairobi City County Government. Consequently, His Excellency Rigathi Gachagua, according to the National Assembly, has grossly violated Article 6, Sub-Article 2, Article 10, Sub-Article 2A, Article 174, Article 186, Sub-Article 1, and Article 189, Sub-Article 1 of the Constitution, as read with the 4th Schedule to the Constitution. Ground 4, the National Assembly accuses the Deputy President of gross violation of Article 160, Sub-Article 1 of the Constitution, which talks about the undermining of institutional and decisional independence of judges. In its submission, the National Assembly argues that Article 160, Sub-Article 1 of the Constitution provides that the judiciary shall be subject only to this Constitution and the law, and shall not be subject to the control or direction of any person or authority. Many international law instruments, treaties, and principles require the guarantee of the judiciary's independence and require all government officers and institutions to respect and observe it. In 2023, His Excellency Rigathi Gachagua, according to the National Assembly, recklessly and mindful of the high calling and dignified status of the office of the Deputy President of the Republic of Kenya, and the need to respect, protect, and uphold the independence of the judiciary, made a scathing public attack against the Honorable Lady Justice Esther Maina, Judge of the High Court of Kenya, and falsely threatened to file a petition for the removal of the said judge in gross violation of Article 160, Sub-Article 5 of the Constitution. The Honorable Judge, according to the National Assembly, had presided over a case in which His Excellency Rigathi Gachagua was a party and had, in the lawful performance of a judicial function, ordered His Excellency the Deputy President to forfeit to the state the sum of 200 million shillings, which she had found to be proceeds of corruption and money laundering. His Excellency Rigathi Gachagua's public attacks, according to the National Assembly, are impeachable offences to the extent that they undermine the functional and decisional independence of judges. If you're just joining us, these are live pictures from the Senate chambers where the trial has taken a short break. The Speaker has gone to draw a ruling on the way forward for this trial, where the Deputy President has been unable to appear to take to the witness stand. His legal representative, led by Senior Counsel Paul Mwite, has asked the Senate to give the Deputy President until Tuesday next week and thereafter make a decision on the way forward. The National Assembly, through its legal representatives, led by Senior Counsel James Orengo, urged the Senate to consider the evidence that has already been forwarded by the Deputy President. Quoting the law, the National Assembly, through its legal representatives, argued that having forwarded the evidence in writing, there may be no need to have the Deputy President give his accounts. The team argued that this Senate can make a decision on that, and it is willing to forego the cross-examination of the witness, who is the Deputy President of the Republic of Kenya. So we are waiting for the Speaker to make a ruling on this request by the Council representing the Deputy President. Ground 5 of the Ground 5 that the National Assembly believes is an impeachable offence is the gross violation
of Article 3, Sub-Article 1 and Article 148, Sub-Article 5A of the Constitution, which talks about the breach
of the oath of office and allegiance. The National Assembly, in impeaching the Deputy President, argued that His Excellency Rigathi Gachagua's actions and utterances outlined in Ground 1, 2, 3 and 4 constitute a gross violation of Article 3, Sub-Article 1 of the Constitution, which requires every person to respect, uphold and defend the Constitution. Further, the actions and utterances of His Excellency Rigathi Gachagua grossly violate Article 148, Sub-Article 5A of the Constitution, which prescribes the oath of allegiance of the office of the Deputy President that obligates the Deputy President to obey, preserve, protect, and defend the Constitution. There's also serious reasons, according to the National Assembly, to believe that the Deputy President has committed a crime under national law pursuant to Article 150, Sub-Article 1B, Part 2 of the Constitution. Under Ground 6, the National Assembly, in its submission, argues that there are serious reasons to believe that His Excellency Rigathi Gachagua has committed crimes under Sections 13, Subsection 1A, and Section 62 of the National Cohesion and Integration Act. Section 13 of the National Cohesion and Integration Act provides that it is an offense for any person to use threatening, abusive, or insulting words or behavior where the person intends to stir up feelings of ethnic contempt, hatred, hostility, violence, or discrimination. The section also makes it an offense to use such words or engage in such behavior when, having regard to all the circumstances, ethnic hatred is likely to be stirred up. The National Assembly argues that besides, Section 62 of the National Cohesion and Integration Act states that a person commits an offense when the person makes statements that are intended or are likely to stir up feelings of ethnic contempt, hatred, hostility, violence, or discrimination. His Excellency Rigathi Gachagua's persistent, inflammatory, reckless, insightful public utterances over the last 2 years, according to the National Assembly, details of which are set out in grounds 1, 2, 3, and 4, establish serious reasons to believe that he has committed crimes under Section 13, subsection 1, and Section 62 of the National Cohesion and Integration Act. Ground 7. Serious reasons to believe that His Excellency Rigathi Gachagua has committed crime under Sections 45, subsection 1, Section 46, Section 47A, Part 3, and Section 48, subsection 1 of the Anti-Corruption and Economic Crimes Act, and Section 2, 3, 4, and 7 of the Proceeds of Crime and Anti-Money Laundering Act. But for the past 2 years, His Excellency the Deputy President has inexplicably amassed a humongous property portfolio estimated at 5.2 billion shillings, primarily from proceeds of corruption and money laundering. The value of the property and wealth that His Excellency Rigathi Gachagua has acquired, according to the National Assembly, over the last 2 years is incompatible with his non-legitimate income, that is 12 million shillings per annum or thereabouts. That His Excellency Rigathi Gachagua has acquired the above-mentioned property and wealth using his 2 sons, Kevin Rigathi Gachagua, or Kevin Gachagua, and Keith Ikenu Rigathi, and other close family members and associates as proxies. The National Assembly argues that His Excellency Rigathi Gachagua and his proxies, especially the 2 sons, have used a number of companies to massively launder money, conceal proceeds of crime, corruption, and benefit from influence peddling. Anytime from now, we will hand you over to the live proceedings of the Senate, where we do expect in a couple of moments the Speaker of the Senate will walk into the chambers to deliver that much awaited ruling on the way forward. The senators are making their way into the chamber, taking their seats, signaling probably the imminent arrival of the Speaker of the Senate. Just a quick recap. The Speaker adjourned the sitting briefly to draft a ruling on the request by the Senior Counsel Paul Muite, representing the Deputy President in this historic trial. The Senior Counsel told the Senate that the Deputy President had fallen ill and he had been in contact with his doctors at the current hospital, and he also did indicate that he didn't speak directly to the Deputy President on orders by the doctors who are continuing to examine the Deputy President. And in response, the National Assembly, through its legal team, argued that they do not need to cross-examine the Deputy President, who was scheduled to take to the witness stand, but the Senate should consider using the evidence presented by the Deputy President in his submission to make a decision. The National Assembly, through its legal representatives, argued that the matter before the Senate has strict timelines, and so it should be dispensed with. And that is the decision that we are now waiting for the Speaker to make. Ground 8 is serious reasons to believe that His Excellency Rigathi Gachagua has committed crimes under Section 132 of the Penal Code and Section 29 of the Leadership and Integrity Act. That His Excellency Rigathi Gachagua has continuously misled members of the public through false, malicious, divisive, and insightful remarks that are contrary to the provisions of Section 132 of the Penal Code and Section 29 of the Leadership and Integrity Act. The National Assembly has illustrated in its submission to this trial that sometime in January 2024, His Excellency Rigathi Gachagua made a sensational but false accusation that Honorable Justice Esther Maina, Judge of the High Court of Kenya, had engaged in corruption. He publicly, according to the National Assembly, said he would present a petition for the removal of the said judge, which he has not done to date. But this was amended during cross-examination yesterday of the mover of this motion, Honorable Ekamas Mwengi Mutuse, who said that he has been made aware that the Deputy President has indeed presented a petition for the removal of the said judge. There on your screen is the clerk of the Senate, and now we await for the arrival of the Speaker of the Senate. Currently the bell is being rung, and we now await the arrival of the Speaker. Ground 9. And there is the Speaker of the Senate, who is now walking into the chambers. This broadcast is brought to you by the Parliamentary Broadcasting Unit in conjunction with the Kenya Broadcasting Corporation.
Order, honorable senators. Let me apologize, I've taken more than the 5 minutes. The matters that had been raised are weighty, but I'm ready with my ruling and I'll proceed to deliver it. Honorable senators, ladies and gentlemen, as you will recall, before the rise of the Senate at 1:15 p.m., the Senate had concluded the hearing of the case of the National Assembly. This included the evidence laid by the National Assembly, including the calling of its witnesses who were examined, cross-examined by counsel for the Deputy President, and re-examined. As the House adjourned, I directed that, as contained in the hearing program in this matter, of the determination of the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, on resumption at 2:30 p.m., the Senate will hear the case of the Deputy President for 2 hours, comprising examination in chief and re-examination, while the National Assembly will have a period of 1 hour and 55 minutes for cross-examination. When the Senate resumed at 2:30 p.m., when the opportunity came for the Deputy President's side to commence its case, Senior Counsel Paul Mwite, counsel for the Deputy President, informed the Senate that he did not know the whereabouts of his client and sought to be allowed a little time to establish where he was. Thereafter, he informed the Senate that he had learned that his client had been taken ill. Asked how he proposed that the Senate proceeds, counsel for the Deputy President requested for time, possibly up to 5 p.m., to try to meet his client before advising on the way forward. Counsel for the National Assembly, when asked to comment on the circumstances, argued that unfortunate as the situation was, this being a constitutionally time-bound process, it was imperative that pursuant to Rule 11 of Part 1 of the second schedule to the Senate standing orders, the proceedings proceed. Now I'll read Rule 11. It provides thus: where the National Assembly or the Deputy President chooses not to appear that fact shall be put on record the Senate shall proceed with its investigations without further reference to the National Assembly or the Deputy President. But the Senate may, for exceptional reasons to be recorded, permit a later appearance before the Senate by the National Assembly or the Deputy President. Now, honorable senators, also noteworthy that Rule 12 provides as follows: subject to these rules, the hearing of the evidence, once it shall proceed and continue until the Senate conclude the hearing of the matter. Following the representation made by counsel for the parties, I suspended the proceedings of the Senate up to 5 p.m. to allow counsel for the Deputy President to report the status of his client. When the sitting of the Senate resumed at 5 p.m., Senior Counsel Paul Mwite informed the Senate that indeed he had contacted doctors at Karen Hospital who were attending to the Deputy President. He further stated that owing to the condition of the Deputy President, he had not been able to access the Deputy President or talk to him.
Senior counsel then proceeded to cite Article 145(6), observing that although the Senate had opted to proceed by way of hearing the matter in plenary, and while Article 145(6) provides for the hearing of the matter by way of special committee, the provision obligates the Senate to accord the Deputy President an opportunity to be heard before a vote is taken on the impeachment charges. He further cited Rule 11 of Part 1 of the second schedule to the Senate standing orders, stating that in accordance with the provisions, the Deputy President had chosen to appear and be presented in these proceedings. Counsel for the Deputy President further submitted that the right of the Deputy President to be given an opportunity to be heard under Article 145(6)(b) of the Constitution is not limited by the 10-day timeline otherwise provided for in this matter. In the end, relying on these provisions, Counsel for the Deputy President requested that the Senate adjourns the matter to Tuesday, the 22nd of October 2024, to enable his client time to be attended to by his doctors. In response, Counsel for the National Assembly, Mr. Gumbo, registered his sympathies to the Deputy President. On the other hand, he noted that the health matters are matters that are beyond human control. However, he noted that the matter at hand was one that was governed by constitutional timelines. Counsel further indicated that Article 145(6) of the Constitution applied to impeachment proceedings in committee and was not therefore relevant to the present proceedings, which had been convened by dint of Article 145(3) of the Constitution. Counsel observed that the dates for the hearing had, by Gazette notice, been set at 16th and 17th of October 2024. Counsel therefore went ahead to observe that His Excellency the Deputy President had robustly participated in the proceedings by filing detailed responses to the allegations as set out by the National Assembly and through various submissions made in the course of the hearing, including cross-examination of witnesses. Counsel then indicated that if any prejudice was to be suffered by the failure of the Deputy President to testify and be cross-examined, this will be on the part of the National Assembly, which had the legitimate expectation of testing the evidence of the Deputy President through cross-examination. Counsel then referred to the practice in the courts, including the Supreme Court, where parties are allowed to file respective submissions, and the advocates are then allowed to appear and highlight their submissions. Counsel argued that noting the Deputy President had filed detailed responses and had the opportunity to cross-examine the witnesses of the National Assembly, the health status of the Deputy President, and the constitutional timelines, and borrowing the practices of the courts, the National Assembly was willing to forego the cross-examination of the Deputy President and requested that both parties be allowed to highlight their submissions during their closing statements. Senior Counsel James Orengo had similar sentiments and cited Article 145(5) of the Constitution, arguing that the right to appear and be represented include the right to be represented by counsel. He argued that the Senate that the greater duty was to comply with the Constitution, and that the Senate could not accordingly go outside the timelines as set out in the Constitution. It is noted that the present hearing was convened via Gazette Notice 163, Volume CXXV1, dated the 9th of October 2024. Via that Gazette notice, I appointed Wednesday, 16th October 2024, as the date for the commencement of the hearing, and further that the hearing will run up to the conclusion of the hearing on Thursday, the 17th of October 2024. As presently
Clerk, call the order, please. Honorable Senators, please let us be seated.
Order number 2, procedural motion to hold sittings on Saturday, 19th October 2024.
The Senate Majority Leader.
Mr. Speaker, sir, I rise to move this procedural motion, which is for the Senate to hold sittings on Saturday, the 19th of October 2024. That aware that the National Assembly on the 8th of October 2024 resolved with the support of 282 members, being at least two-thirds of all the members of the National Assembly, that pursuant to the provisions of Article 145(2), as read with Article 151(b) and 2 of the Constitution and the Standing Order 65(2) of the National Assembly Standing Orders, His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, be removed from office by impeachment on the ground specified in the motion. Whereas by letter reference NA/DLP/TBO/MTS/2024 025, dated the 8th of October 2024 and received in the office of the Speaker of the Senate on the 9th of October 2024, and on the 9th of October 2024, the Speaker of the National Assembly informed the Speaker of the Senate of the approval of the special motion by the National Assembly and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the National Assembly. And whereas Vide Kenya Gazette number 137/18, volume CXX V1 number 163, dated 9th of October 2024, and Article 145(3)(a) of the Constitution, the Speaker of the Senate appointed Wednesday the 16th of October 2024 and Thursday the 17th of October 2024 as sittings convened for the purpose of hearing the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, by plenary. Further, whereas pursuant to Article 145, as read with Article 151(b) and 2 of the Constitution and Standing Orders number 78 and 79 of the Senate Standing Orders, the Senate had the National Assembly on the grounds for the proposed removal from office by way of impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya. And further, whereas pursuant to Article 145, as read with Article 151(b) and 2 of the Constitution and Standing Orders number 178, and Standing Order number 78 and 79 of the Senate Standing Orders, the Senate also had the counsel for His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, during cross-examination of the witnesses for the National Assembly on the grounds of the proposed removal from office by impeachment of the Deputy President of Republic of Kenya. Noting that His Excellency Rigathi Gachagua, the Deputy President of the Republic of Kenya, did not appear during the afternoon sitting of the Senate on Thursday, 17th October 2024, further noting that counsel for His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, sought an adjournment of the Senate until Tuesday, the 22nd of October 2024 at 9 a.m. to allow His Excellency Rigathi Gachagua, the Deputy President of the Republic of Kenya, to appear and give evidence, if any, on grounds for his proposed removal from office by impeachment. Further noting that pursuant to Article 145(4) of the Constitution, a proposed impeachment hearing for the removal from office of a Deputy President must be concluded within 10 days from the date of the reading of the charges, which period in this case expires on Saturday, the 19th of October 2024. Now, therefore, the Senate resolves as follows. 1, to adjourn today's afternoon sitting on Thursday, the 17th of October 2024, and pursuant to Standing Order number 34(4)(c) of the Senate Standing Orders, to hold sittings on Saturday, 19th of October 2024, commencing at 9 a.m. until 1 p.m. and 2:30 until the conclusion of business in the order paper on that day. In order to conclude the hearing and determination of the proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Mr. Speaker, this is a self-explanatory procedural motion that, in light of the request of counsel for the Deputy President, this House adjourns until the closest time possible without violation of the Constitution within which we can sit and conclude on this matter. As I move this motion, though, Mr. Speaker, I must note that the request that came from counsel for the Deputy President, Senior Counsel Paul Mwite, is that we actually sit on Tuesday. I am sure he knows very well the 10-day provision, but I don't know why he wants this House to violate the Constitution, Mr. Speaker, or at least send us into a constitutional crisis. Be that as it may, Mr. Speaker, I want to urge my colleagues that let us sit on that Saturday, despite the fact that I know there are quite a number of Adventists, but duty calls, Mr. Speaker. And this is an important exercise that has the breadth of the country holding still while watching what is happening in the Senate of the Republic of Kenya. Therefore, Mr. Speaker, with those very many remarks, I want to request the minority leader, Senator Justice Stewart Madzayo, to second this motion. I thank you. Justice retired Stewart Madzayo. Sorry, my apologies.
Order, honorable senators. You know, it pays to be attentive. I've just said this is a procedural motion. It does not require notice. Senator Karungo.
Asante Mheshimiwa Spika. Kwanza nataka kuunga mkono hoja hii ya kwamba tuweze pia kupata nafasi ya kuweza kuketi ama kusikiza maoni haya siku ya Jumamosi, kuanzia leo mpaka Jumamosi, kupewa nafasi hiyo. Bwana Spika, tunaelewa ya kwamba hii ni kesi muhimu sana na macho yote katika nchi hivi sasa yanaegezwa katika bunge la Senate. Nataka kumpatia pole sana kupitia kwa wakili ambaye ni senior counsel wetu na ni wakili mkubwa katika Kenya, ndugu yangu Paul Mwite, kwamba yule client wako amekuwa mgonjwa wakati huu. Najua ni ugonjwa ni kitu cha Mwenyezi Mungu. Hatuwezi sisi tukasema kwamba mtu hawezi kuwa mgonjwa. Mtu yote anaweza kuwa mgonjwa. Kwa hiyo nataka umpatie pole. Senate imempatia pole na kwamba tunamtakia kila laheri aweze Mwenyezi Mungu kumpatia nafuu, alafu tuweze kumpata hapa. Bwana Spika, tuko katika panda mbili hivi sasa. Ni mgonjwa na tuendelee, ama ni mgonjwa na tusiendelee. Tumpatie nafasi. Kama binadamu naweza kusema kwamba ni nafasi nzuri tuonyeshe binadamu kama maseneta ama nyumba ya Senate kwamba tumpatie nafasi ya yeye akiwa yuko hospitali aweze kuweza kupata nafuu katika matibabu yake. Bwana Spika, mswada huu umekuja wakati mzuri na kwamba tunaweza kumpatia hiyo nafasi. Naunga mkono hoja hii. Asante sana Bwana Spika.
Now, honorable senators, I'll proceed to propose a question, which is that aware that the National Assembly on the 8th of October 2024 resolved with the support of 282 members, being at least 2/3 of all members of the National Assembly, that pursuant to the provisions of Article 145(2) as read with Article 151(b) and 2 of the Constitution and Standing Order 65(2) of the National Assembly Standing Orders, His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, be removed from office by impeachment on the grounds specified in the special motion. Whereas by a letter reference NA/DLP/TBO/MTS/2024 into brackets 025, dated the 8th of October 2024, and received in the office of the Speaker of the Senate on the 9th of October 2024, the Speaker of the National Assembly informed the Speaker of the Senate of the approval of the special motion by the National Assembly and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the National Assembly. And whereas White Kenya Gazette number 13178, volume CXX V1, number 163, dated the 9th of October 2024, and Article 145(3)(a) of the Constitution, the Speaker of the Senate appointed Wednesday, the 16th of October 2024, and Thursday, 17th of October 2024, as sittings convened for the purpose of hearing the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, in plenary. Further, whereas pursuant to Article 145, as read with Article 151(b) and 2 of the Constitution, and Standing Orders 78 and 79 of the Senate Standing Orders, the Senate heard the National Assembly on the grounds for the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya. And further, whereas pursuant to Article 145, as read with Article 151(b) and 2 of the Constitution, and Standing Orders 78 and 79 of the Senate Standing Orders, the Senate also had counsel for His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, during cross-examination of the witnesses for the National Assembly on the grounds for the proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Noting that His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, did not appear during the afternoon sitting of the Senate on Thursday, the 17th of October 2024. Further, noting that counsel for His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, sought an adjournment of the Senate until Tuesday, the 22nd of October 2024 at 9 a.m. to allow His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, to appear and give evidence, if any, on the grounds for his proposed removal from office by impeachment. Further, noting that pursuant to Article 145(4) of the Constitution, a proposed impeachment hearing for the removal from office of a Deputy President must be concluded within 10 days from the date of the reading of the charges, which period in this case expires on Saturday, the 19th of October 2024. Now, therefore, the Senate resolves the following: to adjourn the afternoon sitting of Thursday, 17th October 2024, and pursuant to Standing Order 34(4)(c) of the Senate Standing Orders, to hold sittings on Saturday, the 19th of October 2024, commencing at 9 a.m. until 1 p.m. and 2:30 p.m. until conclusion of business in the order paper of the day, in order to conclude the hearing and determination of the proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Now, honorable senators, we have been here before. This is a procedural motion. We rarely debate procedural motions. It's either we agree with it or we don't agree with it. And therefore, with your consensus, I may move to put the question. Very well. I will now proceed to put the question. That aware that the National Assembly on the 8th of October 2024 resolved with the support of 282 members, being at least 2/3 of all members of the National Assembly, that pursuant to the provisions of Article 145(2), as read with Article 151(b) and 2 of the Constitution, and Standing Order 65(2) of the National Assembly Standing Orders, His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, be removed from office by impeachment on the grounds specified in the special motion. Whereas by a letter reference NA/DLP/TBO/MTS/2024 into brackets 025, dated the 8th of October 2024, and received in the office of the Speaker of the Senate on the 9th of October 2024, the Speaker of the National Assembly informed the Speaker of the Senate of the approval of the special motion by the National Assembly, and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the National Assembly. And whereas White Kenya Gazette number 13178, volume CXX V1, number 163, dated the 9th of October 2024, and Article 145(3)(a) of the Constitution, the Speaker of the Senate appointed Wednesday, the 16th of October, 2024, and Thursday, 17th of October, 2024, as sittings convened for the purpose of hearing the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, in plenary. Further, whereas pursuant to Article 145, as read with Article 151(b) and 2 of the Constitution and Standing Orders 78 and 79 of the Senate Standing Orders, the Senate had the National Assembly on the grounds for the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya. And further, whereas pursuant to Article 145, as read with Article 151(b) and 2 of the Constitution, and Standing Orders 78 and 79 of the Senate Standing Orders, the Senate also had counsel for His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, during cross-examination of the witnesses of the National Assembly on the grounds of the proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Noting that His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, did not appear during the afternoon sitting of the Senate on Thursday, the 17th of October, 2024, further noting that the counsel for His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, sought an adjournment of the Senate until Tuesday, the 22nd of October, 2024, at 9 a.m. to allow His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, to appear and give evidence, if any, on the grounds for his proposed removal from office by impeachment. Further, noting that pursuant to Article 145(4) of the Constitution, a proposed impeachment hearing for the removal from office of the Deputy President must be concluded within 10 days from the date of the hearing of reading of the charges, which period in this case expires on Saturday, the 19th of October, 2024. Now, therefore, the Senate resolves, 1, to adjourn the afternoon sitting of Thursday, 17th of October, 2024, and pursuant to Standing Order 34(4)(c) of the Senate Standing Orders, to hold sittings on Saturday, the 19th of October, 2024, commencing at 9 a.m. until 1 p.m. and 2:30 p.m. until conclusion of business in the order paper of the day, in order to conclude the hearing and determination of the proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Will as many as of that opinion say aye? Aye. Will as many as of the contrary opinion say nay? Nay. The nays have it. Now, honorable senators, the motion having been defeated, we will proceed with the hearing program as had been circulated this afternoon, in which case then we will move to closing statements by the parties. Yes, Senior Counsel Paul Mwite.
Mheshimiwa Speaker, through you, let me recognize the right of this Honorable Senate to decide any issue, any question put to it democratically, which, Mr. Speaker, is what has happened. Arising from that decision of this Honorable Senate, Mr. Speaker, we as the legal team representing the Deputy President are not able to continue appearing without instructions. So we humbly and with a lot of respect take your leave, Mr. Speaker, and the leave of this Honorable House. Thank you.
Now, honorable senators, we shall move to hear the closing statements by counsel for the National Assembly. Clerk, you may now proceed to read the order.
Order number 3, hearing and determination on the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya.
Counsel for the National Assembly, the floor is yours. You have up to 60 minutes.
Thank you very much, Mr. Speaker, sir. On behalf of the National Assembly, we have a total of 4 advocates who would be sharing the time that is allocated to us. Leading the pack, Mr. Speaker, sir, is Senior Counsel Otiende Amolo, to whom I will cede the floor.
Honorable Speaker, honorable senators, I thank you. And this being my maiden appearance on this matter, I sincerely hope I did not drive my learned friend and his team away. But honorable Speaker, Kenya is indeed a mature democracy. We are so mature that, Mr. Speaker, we gave ourselves the most modern constitution in recent history 14 years ago. We are so mature that 7 years ago, we had the nullification of the only presidential election.
Honorable senators. Senator Fernandi, take your seat. Senator Kipsang, may the Counsel for the National Assembly be heard in silence.
Thank you, Mr. Speaker. 7 years ago, we had the nullification of the only presidential election known to history. And today, Mr. Speaker, we are conducting impeachment proceedings unknown to this continent outside of the removal proceedings in a parliamentary system in South Africa. Mr. Speaker, I want to thank you and the Senate for demonstrating the maturity of a democracy. So much so that even when the Deputy President is unable to appear without anything on record, this Honorable Senate has accorded the Deputy Speaker the opportunity, the Deputy President, the opportunity for his counsel to be present, and they have voluntarily exited. The right to appear in person or by counsel is a right under Article 145. But like every other right, you can choose to exercise it or not to exercise it. The idea and the fact of these impeachment proceedings being open as they are and being so democratic, even to vote on the procedural motion, shows how mature our country has become. Mr. Speaker, before the 2010 Constitution, we would not have been here for this process for 2 days. We would not have been taking this process in the National Assembly. The President would sack the Vice President at whims, including for not liking the color of his shoes. The fact that we are here in a situation where to impeach a Deputy President, we have to go through these processes, Mr. Speaker, it shows our maturity. But let it not be mistaken, Mr. Speaker, as some people have, that the process of impeachment is a criminal trial. When you hear people ask the mover of the motion, do you have any proof? Can you demonstrate? It means they are confusing this process with a criminal process. It is not a criminal process. Mr. Speaker, what we have in impeachment is a halfway house between the whim before 2010 and the beyond reasonable doubt proof in a criminal trial. In the words of Article 50, all you have to show is reason to believe. Reason to believe. What the lawyers would call just a prima facie case. You do not have to demonstrate beyond reasonable doubt. So all the questions that I had my learned friends putting to the mover to prove, to demonstrate, they look good to the public gallery, but they add no value to the test for impeachment. Mr. Speaker, impeachment is like a vote of confidence or a vote of no confidence. Just the same way when you vote the president and the deputy, no one asks you to justify why, because you exercise your discretion. When you lose that confidence, no one should ask you to demonstrate why. That is why it's a political process. Otherwise, it could have been a judicial process or a religious process. Mr. Speaker, it is important to make two distinctions. First, that in this process, you do not have to prove anything beyond reasonable doubt. That's number one. The beyond reasonable doubt can come later when the other processes come in, like the investigative agencies. Number two, Mr. Speaker, in courts, our courts use an adversarial system where you bring all the documents and you are restricted to what you have brought. The process in this house is inquisitorial under Article 145 all the way to 149. And therefore it allows this house to go beyond what the mover has brought or beyond what the other witnesses have brought. And this house has exercised that jurisdiction quite maturely. Mr. Speaker, I want to suggest that the idea of impeachment is one which is legal in process only, legal in process, but political in content and merit. As long as all the legal processes for fair hearing are observed, it is not open to anyone to question the merit in terms of the decision of the National Assembly or the Senate, because the safeguard is in the numbers. That is why before you move it in the National Assembly, you need 117 members. For it to pass, you need at least 2/3. That is the safeguard. The safeguard is not in the legal technicalities. Mr. Speaker, for that reason, while it looks juicy and it looks very good to the gallery to have that intense cross-examination such as we saw of the mover of the motion, Mr. Speaker, it is irrelevant. It is highly irrelevant, and to the untrained eye, they might think you are achieving much, but you are not achieving much. It must be remembered that the impeachment here is of the Deputy President, not the mover of the motion. So however much you discredit the mover of the motion, you do your client no justice when you do not address the substance of what is moved. Mr. Speaker, allow me to refocus on Article 150. Article 150 makes a very important distinction. And I heard the lawyers of the Deputy President saying that, there's precedent. There is no precedent in our courts in terms of impeachment. There is precedent in terms of removal from office of governors under Article 181. The word used is removal. The word impeachment does not appear in Article 181. But when you come to Article 150, two words are used. You can remove the Deputy President first, Mr. Speaker, under 151A, under 151 is removal. To that extent, the question of removal in 151, you can use the same standards in Article 181. But B, it says, or on impeachment. There is no other provision for impeachment, and we have not undertaken impeachment in this country. For that reason, Mr. Speaker, while the wording might look similar, the principles are different. Because for removal, for example, under 151, it's a strict legal process. You have to show and demonstrate that the Deputy President has physical or mental incapacity. But when it comes to impeachment, it's a different matter. It's more of a political matter. Mr. Speaker, impeachment is a demonstration of impropriety, of unfitness for office, of it's taking political responsibility. Indeed, Mr. Speaker, in a representative democracy, it is the way of unvoting someone you had voted. Otherwise, you would be having a fresh election to decide, should we now remove this person from office? It is too expensive. The fact, Mr. Speaker, that you have 82% in the National Assembly voting for impeachment and 2/3 if it succeeds in this House, you translate it to the millions that it represents. In the National Assembly, 82% translate to about 42 million out of the 50 million Kenyans. That is a significant number. Mr. Speaker, if this House is equally to vote, you translate it to the equivalent number of people it's representing. It is not a heavy matter. If it was any less, it would have been a decision for a single judge. Mr. Speaker, allow me to address two things, then I sit, in terms of substance. One, you have 11 charges. 4 of those charges oscillate around one issue, and that is the utterances by the Deputy President. And the charge is he made insightful and discriminatory utterances to the effect that only those who voted for the Kenya Kwanza are entitled to resources and positions in government in Kenya. That is the summary of that charge. That charge is contained in ground 1, ground 5, ground 6, and ground 10. I want to submit, Mr. Speaker, that if you find even only that one charge to have been satisfied, then I want to implore the senators to vote yes for all those 4 grounds together. Has it been satisfied? Mr. Speaker, those utterances are admitted by the Deputy President in the documents before you. The meanings of those words in their variety is known to you and is known to Kenyans. The danger in words is something we know in this country way back in 2007. In our neighboring country, Rwanda, we know what words did. I heard the lawyers of the Deputy President suggest that he did not take any action. Under the law, under Article 10, under Article 27, you do not have to take any action. Utterances are enough, because utterances can do the very damage that the Constitution intends not to be done. Mr. Speaker, what is his response to that charge? There are 2. The first one is he was exercising free speech. Mr. Speaker, that is the easiest to dismiss. I invite the senators to look at Article 33, 2D, Roman 2. It is express, and it says, freedom of expression cannot include advocacy for discrimination, and that's what he was doing. What's the second defense? That whatever he was saying is contained in the various coalition agreements under the Kenya Kwanza coalition that were filed and signed before election. Mr. Speaker, with tremendous respect, allow me to remind the Deputy President that this is the Republic of Kenya, not the Republic of Kenya Kwanza. Mr. Speaker, for that reason, you cannot elevate agreements under the Kenya Kwanza coalition above the legislation of this country, above the constitution of this country. Section 13 of the NCIC Act is very clear that those utterances are unlawful, in fact criminal. Article 10 and Article 27 of the Constitution are equally clear that you cannot make such utterances. So to come and say that I uttered them because they are contained in a coalition for one particular political coalition is in fact an admission. It is an admission of violation of the Constitution. And Mr. Speaker, if members wanted one clear admission of guilt, it is this one. It is not denied, the justification cannot stand, and indeed, Mr. Speaker, once one of the senators asked for the justification, and I heard the lawyers refer to the Schedule 3 of the Political Parties Act. Mr. Speaker, I invite the senators to look at Schedule 3, Clause 3E. It is very specific. It talks of sharing positions in the coalition structure, not sharing positions in government. And to try and mislead this august House makes it an aggravation of a wrong. And I invite you, Mr. Speaker, to find that there was a breach of this. And I think the worst of all is we were able to play a clip of the Deputy President after showing what he had uttered, saying that he has no apology. He said he has no apology. The clip was played here. I invite you to look at the 798 pages that he has filed. There is nowhere where he has rendered an apology. So he leaves you in a position where he says, even if he was not impeached, he will continue doing that because in his view, it is justified by the Kenya Kwanza coalition. Mr. Speaker, I invite the honorable senators to find that this ground has been proved and to impeach the Deputy President on ground 1, ground 5, ground 6, and ground 10 for breach of the NCIC Act, Section 13, and breach of Article 10 and 27 of the Constitution. My last point, Mr. Speaker, allegations of corruption. Mr. Speaker, this House has had the various allegations of corruptions. You had the very direct evidence of Dr. Mulwa in terms of KEMSA. You had the very direct evidence of the Deputy CEO of ESCC. You had the various evidence in terms of Olive Garden, Vipingo, Outfund, and many others. But I will not go there. I will let you assess that, and my colleagues will address that. I want to address one fundamental thing. In your bundle, honorable senators, in volume 2A of the exhibit, you will find reference to a particular court decision. This is the decision on page 60 of 123. That is the decision in Asset Recovery Agencies versus Rigathi Gachagua. This decision was referred to, but I just want to take you directly to the finding on page 77. This was a case that the Asset Recovery Agency filed against the Deputy President. And this case was actually finalized 10 days before the last general election. What did the court find? The court found positively and declared that Rigathi Gachagua was found to have been having funds which were proceeds of crime and therefore liable for forfeiture to the state to the extent of 200 million. Mr. Speaker, it is important to note that in the 798 pages of the document filed by the Deputy President, there is not a single document that shows that this judgment has been set aside, has been compromised, or revoked. In an inquisitorial system, you do not need to restrict yourself. Where there's a judgment produced that shows that you have been found guilty of having proceeds of crime, the expectation would be that you produce a document negating it. The fact that no document has been produced, I invite you to invoke an adverse inference that either there is no such document, or if there is, it does not deal with that finding. Mr. Speaker, I want to submit that there's good reason why that document was not produced. Why would you produce all the agreements of Kenya Kwanza and produce all sorts of other things except one page of a document that is the most important document? As it is, you do not have any document that shows that this finding was negated. Mr. Speaker, I want to suggest that had it been produced, we would then have demonstrated that that document is unlawful. Because in law, and I submit respectfully, once you have been found guilty of what amounts to a criminal offense, you cannot then subsequently compromise it, because this is not a civil claim. A crime is a crime against the state. It is not personal to the Asset Recovery Agency. And therefore, those findings can only be set aside by positive findings of a superior court, and there's none. So the record shows that Rigathi Gachagua was convicted of corruption. And what that means, Mr. Speaker, that not only was he convicted, but even to come here and allege that he was convicted and thereafter, they entered some sort of negotiation, is in itself evidence of abuse of power. Because he was convicted 10 days before election, shortly thereafter, it is alleged they compromised it in what would be an illegality. Mr. Speaker, on that account, ground 7 of the charge must succeed. Respectfully, Mr. Speaker, honorable senators, I plead with you to find the Deputy President guilty of the grounds as charged. Thank you very much. Allow me now to introduce the Honorable George Murugara to take over.
Thank you very much, Mr. Speaker and honorable senators. My name is George Gitonga Murugara, Member of Parliament, National Assembly, and the Chairperson of Justice and Legal Affairs, and I'm here to represent the National Assembly with my colleagues. Honorable Speaker and senators, I'll deal with only one point which supports ground number 11 on the impeachment. And the ground 11 is insubordination and failure to actually act collectively with the other members of the cabinet and the presidency. There was an argument that was raised that some of the alleged misconduct on the part of the deputy president were actually committed when he was not the deputy president, and therefore do not apply to the proceedings before this House. Reference is made to Article 151B of the Constitution, which provides that the ground for impeachment would only be serious consideration of serious reasons to believe that an offense has been committed. There is no time limit that is set, because once there are reasons to believe that an offense has been committed, then that stretches back to whatever time that offense would have been committed. This is to say, if in the pendency of the life of the presidency or the deputy president, it is discovered that before you assume the office, you committed an offense, that forms a ground for impeachment. This leads me to the next argument, which are the admissions that the deputy president actually made before the House. Clearly, he admitted that the issue of shareholding in Kenya was live, and he was part and parcel of it. Therefore, Kenyans were shareholders. He actually admitted in the House and also in the press in the country that he believed the president was behind this motion. He also admitted that he had actually gone against the principle of collective responsibility on the basis that the cabinet had made unconstitutional decisions, which decisions he had to disobey. He also went on to dismiss this parliament as a theater of the absurd, and that he did not expect much from here. The question is this, and that, honorable senators, you have to grapple with. If the deputy president was actually to be saved by this House, with whom would he work? He would not work with the Kenyans whom he has antagonized with his shareholding notion that he has spread across the country. Number two, he would have difficulty serving with his boss, whom he has accused of being behind this motion. He would not actually work with the cabinet, where he is responsible for everything that is done in the cabinet and the sub-cabinet committees brought together by the principle of collective responsibility. He would not be able to work with this parliament, which he has called a theater of the absurd. With whom would he work? This is the question you have to ask yourselves. What we have before us today is like a marriage. And I have to draw that analogy because actually the position occupied by the subject of the discussion and the motion, the Honorable Rigathi Gachagua, is now untenable. He cannot hold that position because his position is irretrievable. He cannot work with any of the organs and bodies he's supposed to work with. Therefore, the position being irretrievable, then it means actually he has to be impeached. And I implore upon you to actually do so. Where a marriage is irretrievably broken, you cannot apply any law. The marriage is gone. Whichever law you try to apply, it does not matter. For the deputy president today, we cannot apply any measure of legalese because this is not likely to assist us in any way. The position remains, this is a political process, these political offices they are holding, and therefore they are irretrievably broken. As I pen off, honorable senators, honorable speaker, sir, I'll refer you to a biblical book in the Old Testament, the book of Jonah, chapter 1. And when the senators retire, they can actually look at that, the entire chapter. What happened here when Jonah disobeyed the command from his superior, and that was the deity? He actually had to flee. And when he fled, he took a ship to a different city, not where he had been commanded to go. What remained was, on the journey, the waters were faced with tempest, and eventually the tempest had to be calmed by tossing Jonah out of the ship. The ship here is actually the presidency. The ocean is actually Kenya. Jonah is the insubordinate deputy president who actually cannot work with the entire government and the country, and whose position today, as he holds, is untenable. With those remarks, I urge you, honorable senators, to actually uphold this motion, and to the best of my belief and conviction, not only ground 11, which I have submitted, the rest of the grounds have been approved. Thank you very much. 2 minutes to Honorable Zamzam, who is also going to make a statement and a submission. Thank you very much.
Mheshimiwa Spika, kama mwakilishi wa bunge wa eneo bunge la Mombasa na bunge la taifa la Kenya, Mheshimiwa Spika, leo nimekuja hapa kuwaletea yale mashtaka ambayo yameonekana katika bunge letu. Mheshimiwa Spika, Mheshimiwa Spika, mengi yamezungumzwa. Mimi si mwanasheria, lakini mimi nazungumza kama yule Mkenya ambaye yuko pale chini, hajui sheria, hajui nini, anaomba amani katika taifa. Mheshimiwa Spika, Mheshimiwa Spika, video zimechezwa katika bunge hili. Tumeona Mheshimiwa Naibu wa Rais akijipiga kifua, hasa kule Taita Taveta. Nimeona Mheshimiwa Spika akiwaambia kuwa hawana shares, na akawaambia nyinyi kama mnataka hisa mungoje 2027, manake hata rais akinambia mimi niweze kuwaletea maendeleo, namwambia kwanza subiri niangalie kwenye mfuko wangu wakiwa kama wako kwenye orodha ya kupewa maendeleo. Mheshimiwa Spika, Mheshimiwa Spika, ifahamike kuna wakati mmoja Kenya iliingia kwenye vita sana. Mheshimiwa Spika, tuliona maiti ya kina mama, mtoto hajui mama amekufa, mtoto alikuwa ananyonya matiti. Mheshimiwa Spika, Mheshimiwa Spika, hatuwezi kutaka taifa hili lirudi kule tena. Mheshimiwa Spika, Mheshimiwa Spika, ndani ya Mombasa nina wajane ambao wananitegemea sana. Mheshimiwa Spika, uniletea malilio yao, na leo mimi kama mama kaunti wa Mombasa nalia kwa sababu ya mayatima ambao waliachwa na ndugu ya naibu wa rais. Mheshimiwa Spika, haiwezekani kuwa leo mimi na mume wangu tutafute mali yetu na tuna watoto wetu, kisha akifa aende mbele ya Mwenyezi Mungu nije nipokonywe mali yangu niache na watoto wangu wakihangaika. Mheshimiwa Spika, ukiangalia umri ya hawa watoto wa ndugu yake Mheshimiwa naibu wa rais wametoshea kupewa urithi wao. Mheshimiwa Spika, lakini hata kuna tetesi mwingine yoozea kule kwa jela. Mheshimiwa Spika, kwa hiyo Mheshimiwa Spika, mimi nasema, nilisikia mwanasheria akisema to save makanga. Mimi nasema makanga ameiba pesa ya abiria, dereva hana pesa ya kupelekea mwenye gari. Kwa hiyo mimi nasema wamwache dereva apeleke abiria mpaka station ya mwisho, kisha akifika kule atajua atatafuta makanga mwingine namna gani. Mheshimiwa Spika, hatuna sisi uchungu na watu wa mlima, lakini tunachosema tulikuwa na Uhuru, tulikuwa na Kibaki, tulikuwa na Kenyatta, hatukuwahi kuona mambo ambayo tumeona kwa deputy president. Mheshimiwa Spika, huyu ni sumu, atavuruga Kenya, ataharibu Kenya. Naomba bunge hili la Seneti, amani ya Kenya iko kwenye mikono yenu, na waomba mtoe uamuzi wa uhakika. Huyu jamaa hapendezi kabisa kuwa katika nafasi ambayo yuko ndani sasa, na waomba kwa heshima na taadhima tuweze kumtimua leo, Kenya iweze kupata mtu ambaye atamsaidia rais kufanya kazi akiwa ameweka amani na umoja wa Kenya mbele. Asante sana Mheshimiwa Spika.
Mr. Speaker, sir, very briefly, I will wrap up the submissions on the part of the National Assembly. I'll endeavor not to repeat what has already been captured on the record. Mr. Speaker, sir, I've agonized and reflected on the place of impeachment proceedings, not just in our country, but across the world and across other democracies. Mr. Speaker, sir, I've had occasion to look at the history, particularly of the United States of America, from the days of Andrew Johnson in 1868, Richard Nixon in 1974, Bill Clinton 1998, and Donald Trump 2019. Mr. Speaker, sir, I asked myself, what does impeachment proceedings seek to serve in a democracy? In my reflections, one of the clear conclusions is that it is a check and a balance through which the populace can then hold their leaders accountable. It is an avenue through which the populace can ask their leaders whether they're doing that which is in keeping with the social contract or the understanding that they had at the point of election or delegating their direct powers to those elected leaders. So in the context of Kenya, where then do we find impeachment? Mr. Speaker, sir, our history has taught us very bitter lessons. We remember the events that bedeviled our country after the 2007 elections. It is after those events that we gave ourselves a new constitution. In that new constitution, Mr. Speaker, sir, we found it necessary to, in an unprecedented way, speak about our values, speak about the fabric of our society, the things that pull us together, the things that we share as a people. The preamble to our constitution, in particular, paragraph 3, reads, "We, the people of Kenya, proud of our ethnic, cultural, religious diversity, and determined to live in peace and unity as one indivisible sovereign nation," and continues so on and so forth. From those words, we realize what the thinking of the Kenyan people was right from page 1 of framing of our constitution. We then went to substantive provisions. A lot has been said about Article 10 of our constitution, to the extent that it speaks to the values that as a people we want to be associated with. We have dedicated a whole chapter of our constitution to the questions around leadership and integrity. It then tells us how central the values that we hold are to each other as a nation. Now, if we look at impeachment from that lens, then we realize and appreciate that impeachment then comes in to hold our leaders at an even higher pedestal, so that we have a tone at the top that is acceptable, a tone that gives us what has been called elsewhere political hygiene. We have had occasion in this country where people who have been in positions of leadership have been treated in what other people have thought has been harsh treatments. But it is because when there's a tone at the leadership to be set, it must be clear, it must be vibrant, and it must be the right tone. We've had leadership, people from the leadership who've lost their office because of having pinched somebody. We have people who have lost their offices because of utterances that were considered inappropriate. A slap has gotten somebody to go through a fairly painful process. It is because the slap is not necessarily the issue, it is the message that it sends. And so similarly, when we talk about our leaders, we then must ask ourselves, what does one wrong word do to the fabric of our society? It is on the basis of that background that we then consider the impeachment motion that is currently before this House. My colleagues who have spoken before me have taken us through the provisions of Article 150, 1B, which then speaks to the very grounds that this House should consider in whether to impeach His Excellency, the Deputy President, or not. I wouldn't want to go into those grounds because the record before this House contains material in support of those grounds. I would urge, Mr. Speaker, sir, that now that His Excellency, the Deputy President, has had occasion to present material before this House, that this House could consider in response to the motion for impeachment. When you retire to debate, to deliberate, we urge that you take into consideration the entirety of that material. We also ask that you also take time to look at what the mover of the motion presented before this House, as well as all the witnesses, including what came from public participation. That would give us an opportunity to, in a very objective way, reflect on what and how to deal with the questions that have been presented. I need not go into the specifics of each of the charges, but if I was to give examples, when we have a leader occupying the high office of the Deputy President of this country, somebody who is required by the Constitution to take an oath confirming or affirming to Kenyans that they will not divulge whatever comes out of secrecy, out of confidential conversations that come to their knowledge by virtue of the office that they occupy. If that person then defies that bond or that commitment that they've had with Kenyans, it is a gross violation. Similarly, when we have somebody occupying the space of the high calling of the office of the Deputy President, admitting issues that would amount to conflict of interest between his personal interest, his family interest, and which have financial implications. Again, our laws then dictate that those are reasons that would amount, would be sufficient to impeach such a Deputy President. We've had examples that have been given about utterances that have been considered to be unpalatable. Again, looking at the entire framework of what our Constitution anticipates, looking at what those words would mean to a man off the streets of Nairobi, off the streets of Mombasa, or any other place. If we all come to the understanding that those words taken in their natural meaning could cause some measure of discomfort, they are considered to be divisive, they are considered to be of such a nature as to bring or sow seeds of discord between us as people in this country, then it is the responsibility of this House to speak, and to speak on behalf of the people of Kenya, because it is one way of ensuring that there are checks and balances that flow from the constitutional powers vested in this House. Mr. Speaker, sir, as has been demonstrated through the many tons of documents that have been availed before this House, the cross-examination that has attended to the witnesses that have been before this House, and the material that has been placed by the mover, by all the parties who've had an opportunity to participate in the proceedings of this House, we have absolutely no doubt that this House is perfectly capable of making the appropriate decision in each and every of those counts. And just for emphasis, Article 150, Subarticle 1B gives us 3 grounds. We do not have to have beyond 1. Any one of those is more than sufficient to make the call or to pull the trigger on an impeachment motion. Mr. Speaker, with that, I rest, and we thank you for according us this opportunity this evening. Most obliged.
So, are you done now with your submissions?
Yes, Mr. Speaker, sir. We are done.
Thank you. Now, honorable senators, I'll refer you to the program. You will notice that after the closing statements from the parties, the Senate is supposed to move to a closed session to deliberate on the issues that have been raised. And that is pursuant to our rules of procedure. That is demanded of us by the rules of procedure. So at this juncture, I will allow the parties to retire as the Senate moves to a closed session. That closed session will take us not more than half an hour. After that, we'll come back. Once we are back, there's going to be a special motion contained in an order paper. That is the motion that will allow debate culminating into honorable senators getting the opportunity to cast their vote on each of those charges, of the 11 charges. So, Counsel for the National Assembly, you may now retire. Once we resume open session, of course, you'll resume your seats.
Thank you very much, Mr. Speaker, sir.
The media.
Huu ambapo ni dakika 20 baada ya saa moja. Kumbuka ni baada ya mdahalo mzima wa iwapo maseneta wataendelea kujadili hoja hizi za kubanduliwa kwake naibu rais Rigathi Gachagua na kupiga kura leo ama wasubiri hadi Jumamosi kama ilivyokuwa imependekezwa. Kumbuka hii ni baada ya mdahalo wa muda wa zaidi ya saa 2 kutoka mwendo wa saa 8:30 ambapo walifaa kurejea tena baadaye saa 11 walipotoa nafasi kwa mawakili wake Rigathi Gachagua, lakini wakashindwa kumwasilisha kwa kusema kwamba alikuwa ni mgonjwa na ugua na amekimbizwa hospitalini katika hospitali ya Karen. Lakini baada ya kupiga kura kwa sauti, maseneta wamekubaliana kwamba wataendelea kujadili hoja hizo, kuzipiga msasa, kuzitathmini tena baadaye wapige kura baadaye usiku wa leo. Na tumemwona Spika wa Seneti Amason Jeffa Kingi akitoa mwelekeo wa pumziko fupi, tena baadaye watakuwa narejea na kuendelea na hoja hizo kujadiliwa tena baadaye wapige kura. Kitu ambacho tumeshuhudia ni kwamba waliosalia katika ukumbi huu wa Seneti ni mawakili wa bunge. Tumemwona Chindo Molo pale akitoa hoja zake. Eric Gumbo pia alikuwa mmoja ambao alitoa hoja, wakiwa hawa ni mawakili wa bunge ambao wanaunga mkono hoja ambazo ziliwasilishwa na mbunge Mwingi Mutuse bungeni, zikiwa na makosa matatu makuu na vipengee 11, vipengee ambavyo wanasema kwamba vina uzito kupita kiasi, kwamba Gachagua hatapona na watafanya vyovyote wampigie kura ili iweze kung'atuka. Lakini pia tumeona baadhi ya maseneta ambao ni wenye kuegemea mrengo na upande wa naibu rais Rigathi Gachagua wakiondoka katika Seneti, mawakili wake pia wakiongozwa na Elisha Ngoya, Ndegwa Njiru pamoja na Tom Sharia. Pia tumemwona Swaya Ogeto na John Njomo wakiondoka katika majengo yale na ukumbi ule wa Seneti, kuonyesha kwamba hawako tayari kuendelea kusikiliza, maana ombi lao lilikuwa ni kwamba apatiwe siku kadhaa ili waweze kumleta siku ya Jumanne wiki kesho. Lakini kipengee ambacho kimeleta kivangaito na mdahalo mpana zaidi ni kipengee cha 145 ambacho kinatoa hoja na mchakato mzima wa kuweza kubanduliwa kwa rais, ambapo vile vile kinaleta mwavuli ule pia wa naibu rais namna gani anaweza kubanduliwa na Seneti kupitia kikao maalum, kamati maalum ya maseneta 11 ama kikao kizima cha Seneti kama tulivyoshuhudia. Na mwishowe ni kwamba inavyozungumzia pale sehemu ya 5